Well, good morning, everyone. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for review of the exposure draft legislation combating anti-Semitism, hate and extremism Bill 2026. These are public proceedings, and although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera, I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege, unless you are giving evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. I remind all present that as Chair, I'll ensure that proceedings are conducted in an orderly, respectful and courteous way. In accordance with the committee's resolutions of August 26 of last year, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will also be published on the Parliament's website. Witnesses are advised that the committee's review concerns the exposure draft bill, not broader issues that may be subject to other inquiries, including royal commissions, and that evidence will only be taken by the committee where it relates to some or all parts of the proposed new legislation. In addition, Parliament imposes itself a sub judice convention, which means avoiding public discussions that could involve a substantial danger of prejudice of proceedings before a court or other tribunals like royal commissions, and unless there is an overriding public interest requirement to do so. Now, the hearing today is being conducted with members of the committee appearing here in Canberra, but also online via video conference. Members participating remotely are reminded to mute your microphones when you are not speaking. I'd like to welcome representatives of the Executive Council Australian Jewry and the Australia's Special Envoy to combat anti-Semitism to give evidence at this public hearing today. Now, for the Hansard record, could I ask that you all state your full names and the capacity in which you appear before today's hearing? And I'll start with the Executive Council.
I'm Peter Wertheim. I'm the co-CEO of the Executive Council of Australian Jewry, and I appear with Simon Abel, who is the Head of Legal of our organisation.
Thank you. I might ask now if, Anita from Australia's Special Envoy to combat anti-Semitism.
Yes, my name is Anita Stucken and I'm Assistant Director Legal at the Office of Australia's Special Envoy to combat anti-Semitism.
Thank you. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in evidence today, as written answers to any questions taken on notice will have to be provided within 24 hours of receiving the Hansard transcript. Now, I'd like to ask or invite you, if any of you have an opening statement to provide this committee before we start off with questions. Peter, do you have any opening statements?
Yes, look, a very brief one because I know time is short. Overall, I'd like to say that we welcome the introduction of the draft legislation with qualifications. There are a number of features of the new legislation which we have long called for and which we welcome. But in summary, there are also some significant shortcomings and drawbacks which we have pointed out with previous iterations of anti-hate speech legislation, and we're concerned that those have been preserved to some extent in the current round, and we are concerned that if they are not addressed and rectified, that we're going to be back here again in 2 years or maybe even sooner, wondering what went wrong and why we have to go through yet another round or another set of iterations of this legislation. I'm happy to go into the detail of what we consider to be the shortcomings as well as the positives, but I think that's the kind of the high-level introduction that I would like to give you, and given the shortness of time.
I appreciate that. Anita, did you have an opening statement or any remarks you'd like to make? Okay. Look, I might just ask a couple of questions and then I'll hand over to the opposition. And look, just in light of your statement and earlier public comments that you have made, is it correct that the Executive Council of Australian Jewry's position is that there is a need for the Commonwealth to strengthen its hate speech laws?
Yes, we do say that, and that's a position we've consistently held publicly and before parliamentary inquiries going back at least to 2010. And the need for such legislation has been highlighted not only by the anti-Semitic terrorist attack that occurred at Bondi Beach last month, but also the climate of hatred that preceded it.
And it's fair to say you have been calling for some time, well before the attacks that occurred late last year.
Yes, I mean, you can go back to 2024 when the criminal code hate crimes legislation was introduced. We made a detailed submission to that parliamentary inquiry. I've forgotten the exact committee, but again, we pointed out that while some of the new provisions that were introduced at that time were welcome, there were still significant shortcomings, and in particular we pointed to the absence of a serious vilification provision that had previously been mooted but not included in that bill. So that was just the last occasion, but you can go back to many occasions even prior to that when there's been consideration of anti-hate crimes legislation and amendments to the existing legislation, and we've made similar points.
Moving to the exposure bill, and particularly to the aggravated sentencing factor, what are your views on this provision?
Look, you're talking about the aggravated sentencing provisions for ordinary, what might be called ordinary crimes that that have a hate motivation as a factor.
Particularly, and maybe this might help you with your response, but your views on it being targeted only to race,
Yes.
ethnic or national origin as the protected attribute.
Well, as a general proposition for the entire suite of provisions that are contemplated, it's long been our view that the protections that are contemplated for race should also be available for individuals who are the subjects of hate crimes or the promotion of hatred on the basis of other inherent attributes such as sexual orientation, gender identity, age and disability. I think religion is a bit of a question mark because it's not so much an inherent attribute as it is a set of beliefs. It's a bit of a grey area, that one, and I think that needs perhaps a little closer consideration. But certainly with the other attributes that I've mentioned, which are inherent attributes, to attack a person for who they are, in effect, is something that I think should actually attract enhanced penalties and should be considered as an aggravating factor.
Regarding the new racial vilification offence, does the Executive Council have, I think, has previously raised some concerns with the standard of proof being intention as opposed to recklessness? I just wanted to understand a bit more why you've come to that viewpoint.
Well, originally we were prepared to consider an offence that was limited to intention as the mental element. That was about this time last year when the bill was introduced to that effect by Allegra Spender MP, and we supported that bill. And we were prepared to live with an offence that was limited to intention as the mental element. Since then, of course, we've had the events at Bondi Beach and the events and also the events that preceded it, the climate of hatred and vilification that preceded it. And so we think that setting the bar at intention would be too high and would not capture some egregious examples of hate speech that we think should be captured. I mean, just to give you we can give you some specific examples in our written submission, which we're going to provide to you by close of business tomorrow. But in my own discussions with the government and with departmental officers of various departments, it's been put to me that setting the bar at intention could actually exclude a lot of antisocial activity that ought to be covered. And the kinds of speech I'm talking about is where somebody says something that is subliminally and indirectly alluding to the promotion of hatred, but doesn't quite get there to the point of establishing an intention to do so. But there's clearly an indifference amounting to a reckless indifference as to whether it has that effect. And we think that that should be captured because very often bad actors out there are well aware of the law, they're well aware of the limits that they can go to, and are prepared to push those limits to the absolute extreme. And unless you have a recklessness element, which is usual for criminal offences generally, they'll be able to essentially get away with that sort of strategy.
Yeah, I appreciate that. Because, I mean, I also wanted to ask, though, then what's your view on the inclusion of the religious text exemption?
Oh, totally opposed to it. We think that that is a completely misconceived provision, and we've made that very clear in all of our discussions with government. It won't come as a surprise to anyone that we think that that is totally misconceived. The exemption would be for anything that quotes or references religious texts for the purposes of religious teaching or discussion. Now, we think that the entire concept is misconceived and outdated, because none of the world's recognised religions would openly avow to promoting racial hatred intentionally, knowingly and deliberately. They might say that some of our texts have been and can be misinterpreted in that fashion. But people might quote from a religious text and inadvertently give the impression that they're promoting hatred. But that is not what the texts actually mean. And all of the recognised religions would disavow any suggestion that they are intentionally out to promote and stoke racial hatred. So if that's the case, and given that intention is such a high bar to prove as the mental element, then there's no justification for having that exemption there, because in any circumstances where say, a cleric might give a sermon about something that might be interpreted as promoting racial hatred, that would not be covered by the offence because of the intention requirement. And where intention is proved beyond reasonable doubt, which is the highest evidentiary standard, then of course that would be caught by the proposed section, and we would say it should be caught, because the intentional promotion of hatred is not really something that ought to be protected under any circumstances, including using religion as a cloak. And the major authorities of each religion would tell you in any event that that's not what their religions teach. In fact, it's the exact opposite of what their religions teach, because it's so inconsistent with their basic principles about the sanctity of human life and the inviolability of human dignity.
And as it's currently drafted, do you think that the provisions then, would you seek any amendments to it? Too broad? Just remove the provision?
Just get rid of it. We would say that provision just does not belong there. It doesn't belong there because it suggests that somehow one can intentionally promote racial hatred and do so intentionally within the bounds of religious doctrine, and we don't believe that to be true.
I guess,
to the extent that it is true, it's not a justification.
yeah. And I
Not for
think
intentional promotion of hatred. I'm sorry.
that's all right. And I was just going to say, though, in just to add to what you said, I guess the response after the horrific, anti-Semitic attacks and terrorist attacks that occurred, some probably have argued, and there will be some as part of this process through this committee, that such provisions should be there to capture some of this hateful speech. But I just wanted to really understand then, so ultimately what you're saying, that the bill should really focus just at the race, ethnic or national origins, as you had indicated a bit earlier, rather than this religious text?
Yes, I mean, let's just put this in context. I mean, the bill as it is would proscribe the intentional promotion of hatred on the basis of race. So on that assumption, is there any justification for exempting so-called religious discussion? And to the extent that a religious discussion or any discussion involves the intentional promotion of hatred on the basis of race, we would say it should not, in any event, it should not be captured and it should not be exempted. But in any event, most religions are saying that this is not what they are teaching, this is not the intention of behind them. And where a prosecutor is unable to establish that intention, then the question won't even arise in the first place. But where there is evidence of intention to promote and stoke hatred on the basis of race, then religion is no excuse.
Yeah. I'm mindful of my time, so I'll just be quick with the last remaining questions. But I just want to ask, does the Executive Council support the increase then in the maximum penalties for existing hate crimes offences in the Commonwealth Criminal Code?
We do, but we also believe that it's necessary to introduce mandatory minimum penalties for the whole range of Division 80 offences. And I might let either Simon or Anita or both address that in more detail.
Okay. Before we do that, I'll also ask this other question then. Do you have any views then about the new listing regime for prohibited hate groups? Like, do you believe there's enough safeguards in place before a group can be listed?
Yes, I think that is one of the positives of the legislation, and we have welcomed that. We've been mindful of the fact for many years now that there are groups out there that act to promote hatred and to stoke it and to exploit it for the purpose of inculcating extremist attitudes and behaviour among some of their followers, but they fall just short of the requirements needed to list the organisations as terrorist organisations under the current provisions of the Criminal Code. Again, this goes back to these sort of actors becoming increasingly sophisticated, getting legal advice about how far they can go and so on. So having a secondary regime to capture extremely antisocial behaviour that falls short of what is necessary to list an organisation as a terrorist organisation is a good step forward, and we welcome it. And I think there are sufficient safeguards in it.
Okay.
Yeah,
now, Simone, did you want to add?
Yeah, I think it is the right step forward, and it's something that ECAJ proposed, I believe, in 2021, so well prior to kind of this recent uptick in hate. However, the bill at the moment requires an assessment around, the potential commission of a hate crime. And I guess what we would say is that if an organisation expressly or by necessary implication in its objects promotes the hatred on the basis of a protected attribute, then obviously that should in and of itself mean that the organisation should fall within the listing regime. There should not need to be an assessment as to the likelihood of the commission of a hate crime, because if an organisation is inculcating individuals in Australia and promoting hatred in that way, then logically that really should mean that it falls within this new regime.
Anita, did you want to add anything to any of the questions I'd asked to the Executive Council?
I would just add, in respect of the increase in penalties for Division 80 hate crime offences, that the ECAJ office would repeat and endorse the recommendation made by ECAJ at the start of 2025, that those offences also have a fault element of recklessness rather than intention, so that they operate effectively. Of course, if the existing Div 80 hate crime offences aren't capturing the relevant conduct, then an increase in penalties would be to no avail. Having said that, of course, we would support any increase in the penalties for those offences because they are very serious.
Is there anything else around the world that you've seen that we might want to consider that's been effective in terms of other provisions?
Canada, I think.
Yeah, Anita, do you want to speak to Canada and then maybe I'll speak to the UK?
In ECAJ's submission to the recent New South Wales review conducted by the Honourable John Sackar, ECAJ made some comments with respect to the Canadian offence of the willful promotion of hatred. That offence differs slightly from the current Commonwealth proposed offence in that it does not include any requirement to cause intimidation or fear. And it includes a form of good faith defence with respect to religious discussion, but not in the breadth of the current exemption. The Canadian government has actually announced its intention to remove that defence for genuine religious discussion. It's not been successful in the several decades of its operation. More broadly, our office would point to the Canadian offence as illustrating the fact that the threshold of hatred, and in particular the intentional promotion of hatred, sets a very high threshold, and that there's no need for additional requirements, in particular the requirement to prove fear within the offence. The offence already captures a very narrow scope of conduct, and that's illustrated by the Canadian offence.
All right. Now, I'm going to hand over to the Deputy Chair and then Senator Duniam. Deputy Chair, you have the call first.
Thank you, Chair, and thank you so much for all your attendance here. And I know it's been a very quick turnaround, and we've seen other experts not be able to provide evidence because of that turnaround. So I just want to say thank you. I heard your views around the bill that allows the defence for quoting religious texts, but do you agree this could be exploited by hate preachers to justify anti-Semitic rhetoric?
Yes, in fact, we have the evidence of the case of which I brought together with one of my colleagues last year in the federal court against Wissam Haddad. Mr. Haddad has not denied having a history of association with some notorious people in Islamic State and also in recruiting young men for extremist activity. So that was the background. But he had made a number of sermons, I think they were characterised as, in November 2023 to a prayer group of up to 200 people. And those sermons had included a number of statements involving derogatory generalisations about Jewish people. And in the course of that, he had referred to or quoted certain religious texts and then extrapolated from that justified hatred against Jews generally. And he made a number of assertions to that effect. The court, we took him to court under the provisions of Part 2A of the Racial Discrimination Act, which of course are civil provisions, not criminal. But in the course of the trial, he sought to argue that he was simply quoting from religious texts and exercising his religious freedom and so on. And the court, of course, did not accept that argument, and ultimately he was found to have contravened the anti-racial hatred provisions of the Racial Discrimination Act, and certain injunctions and other declaratory orders were made, and that was the end of that particular proceeding. But the significance of it is that the defence of citing religious texts was raised in that context. And whilst it was dismissed in the context of civil proceedings, if a similar sort of excuse were to be raised in the context of criminal proceedings, where one has to prove intention and one has to prove it beyond reasonable doubt, I think a prosecutor might well be deterred from the obvious course of prosecuting such statements in the context of this proposed legislation if it came to making a decision, because they would possibly come to the conclusion that with that exemption there could be no certainty of success with the prosecution, and that the defendant would merely have to state that they were quoting from religious texts and demonstrating that, and it was in the context of a prayer meeting, and that'd be the end of it. It would escape. I think it would escape prosecution, and even if there was a prosecution, it would possibly fail with that exemption included.
So Peter, just so I get some clarity, can you confirm you believe Wasim Haddad would be protected by this exemption?
I think if the identical circumstances arose with Mr Haddad, there is a significant chance that he would escape liability under this section, and for that reason probably escape even the attempt of prosecution.
Thank you. Do you believe that everyday Jewish Australians would feel protected knowing this defence exists?
I think it would cause great consternation, and has caused great consternation based on the feedback that we've received, that this is a very wide loophole that would be exploited to render the introduction of this offence ineffective.
Peter, were you consulted about this exemption before it was announced?
Well, I don't want to go into confidential discussions, but it's no secret that these sorts of issues have arisen in the past, both in the context of the current legislation and in the context of equivalent legislation in New South Wales. And so these are not new issues, and our views, as Anita pointed out, were placed very forcefully before His Honour Justice Sakar, who has done a report in relation to the relevant provisions of the New South Wales legislation, and that report has not been released. So we don't know what it said. But our own views are very clear. The government was well aware of them, and I don't think I need to go beyond that.
Are you aware of any other Jewish peak body that supports this exemption?
No.
And were these discussions confidential in nature because that was how it was described to you, or were you providing feedback on an exposure draft that you were allowed to see?
Well, again, I don't want to go into the detail, but it's not unusual for governments that are contemplating introducing legislation that might have a particular impact on one section of the community to consult with them beforehand, even with exposure drafts, and to seek their views. So that would have been entirely unexceptional. And again, I'm sorry if I sound a bit vague, but I don't want to breach any confidences here.
Peter, you're not vague, mate, and I'm just trying to, it's been a quick turnaround for us to see it as well. I'm just trying to do my best with trying to understand what you've gone through, how you see this as well. And I don't mean to use this language, but I think I have to, and I'd like your opinion of it, but I just want to give you warning that it's probably not language that you're going to like. Do you believe terms like globalise the Intifada and death to the IDF will be prohibited under this bill?
I think it would be a moot point. I think they should be prohibited under this legislation. Because, I mean, what globalising Intifada, I mean, the broad Australian public may or may not be aware of what that really means. The Jewish community knows exactly what it means because during the Intifada, suicide bombers were sent into Israel. They blew up civilians on public transport, in supermarkets, at discotheques. There was even the shocking case of a 15-year-old Australian girl who was Malky Roth, who was blown to pieces in a pizza parlour in Jerusalem. So we know exactly what Intifada means, and to say globalise the Intifada means spread it around the world and bring it here to Australia. And we think that is promoting hatred, and we think it's intentional promotion of hatred in most contexts, and therefore it should be proscribed. But I'm not sure that a prosecutor not having that knowledge and that background would necessarily understand that. I'm not sure that a court would understand that. So it's difficult to predict what the outcome would be if a prosecution were to be brought about that. And the same, with death to the IDF. I mean, on the face of it, it just seems like a slogan about the Israeli military. But when you understand that it's being used in protests and to justify violent actions against Jews, not in Israel, but all around the world, it has a meaning that might not be apparent to an uninformed observer.
Yeah, Peter, the reason I ask is because yesterday a departmental official couldn't answer whether the Intifada slogan was captured or indeed whether a fatwa was a religious text. Does that concern you, that a departmental person can't answer this?
Well, look, I think it's a concern because it's indicative not of a level of ignorance of a particular departmental officer, but I think a generalised lack of understanding and lack of insight by people who are not as intimately concerned about that particular conflict as those who are directly involved. I think it's just human nature that you tend to be more knowledgeable about the things that are closer to home and less knowledgeable about things that affect other people. And that's really what I'm concerned about, that given the fact that 99.6% of the Australian population are not Jewish and probably have only a very generalised understanding of the context, that the meaning will not necessarily be properly understood even by a well-informed court.
Yeah, and I agree. And, mate, I only ask because if the people who wrote the legislation can't explain it in its operation, how can we consider it properly? But I just want to say thank you for your time. And, Chair, I pass over to Senator Dunningham.
All right, thanks. Deputy Chair, Senator Dunningham.
Thank you, Chair, and thank you all for your attendance today. In general terms, I just want to get a sense, perhaps starting with you, Mr. Wertheim, and putting aside the exemption that is in the proposed bill, the exposure draft, do these laws do what it is the community you represent want them to do? Is that your belief at this point in time based on what you've read?
Well, overall, we'd rather see the current round of legislation passed than not passed if it came down to that stark choice. But that's not to detract from anything that any of us have said about what we see as the current shortcomings in the bill. As I said at the outset, I just don't want us to be here again in 2 years' time talking about the next round of legislative amendments to fix up all the problems of the previous attempts that have been made by the Parliament to address this problem, when we can quite clearly fix all of those defects now. we can identify them now. This is not a new set of issues, even though the bill is new and it's being done on an urgent timetable, understandably. The issues that it raises are well-worn ground for all of us. We've all been debating these issues with previous iterations of this legislation going back for 15 years or more. So we'd like to see what we perceive as the shortcomings of the current bill fixed up in the light of that history and passed. But if we have to just take what is on offer now rather than nothing, I think we will take what's on offer now.
Well, and to that end, I suppose as an opposition, we've made it clear that this should not be a take it or leave it proposition, and that it is important to ensure that we get this right. And there's a range of stakeholder groups who've said there are changes that need to be made to this legislation in various ways, a number relating to the exemption we've already talked about. But forgive me, I'm not completely familiar with all of the suggestions that ECAJ have made to remedy the issues you've identified with the bill. But, I mean, you know our timeline. At this point in time, we're returning here on Monday for the necessary condolence motion, and then on Tuesday to debate the legislation and pass it in pretty short order. I mean, would it be better, because as you say, you'd rather not be here in 2 years' time fixing up what it is that we didn't get right this time round, perhaps because we've rushed it? Is it better that we try and take our time to get the elements of the legislation that need fixing now right, instead of just passing it as is?
Well, we will have a very detailed submission to you by the close of business tomorrow, and I'm sure Anita can give you a timeline on a SECA's submission. You'll have all the detail about where the defects are as we perceive them and what is needed to be done to rectify them. So when you say, should we be taking this more slowly, there is I think a legitimate urgency about this legislation in view of recent events. And I don't think that it should detract from the capacity of the Parliament to deal with the bill effectively. As I said, these issues are not new. We have traversed them before with previous rounds of legislation. We can deal with the relevant shortcomings in relatively expeditious fashion. And I think now is the time to do it. And of course, we would love to see the bill amended in the way that we have been proposing and will propose in detail in our written submission.
Yeah, okay. Ms Stucken, did you want to add anything to that?
No, the office will also put in a submission before the deadline close of business tomorrow. Okay, well, I won't ask you to run through, either of you, what the elements are, given the shortness of time, and we will await those submissions with interest. I guess it is a hallmark of this process, which is extremely truncated for good reason, but also it does make doing the job here very, very difficult. I do think we need to do our best, and that's our intention. Again, some of the evidence you may have seen yesterday, and Mr Thompson referred to it, the department unwilling and for good reason unable to provide hard and fast answers about what would be caught, what would not be caught. I mean, I accept your point, Mr Wertheim, that the majority of Australians wouldn't know what the slogan "globalise the Intifada" means, but you and your community do, and it is said with often, I believe, with an express purpose to instil in you a particular feeling, hence what we're talking about here. The officials yesterday kept saying, well, it's a matter for the courts. And so you talked about the inclusion of the intent threshold or demonstrating intent. I mean, that's a concern you have. Can you just step me through that a little bit more so I understand what the alternative would be from ECAJ's point of view?
Well, the alternative is to treat the offence in the same way that other criminal offences are treated, and that is to have a mental element that encompasses either intent or recklessness. That's the short answer to your question. And I think if the legislation were amended to include a mental element of recklessness, it would lose very little in terms of its public acceptability or whatever the concerns may be at setting the mental element so high. And it would also significantly enhance the potential effectiveness of the legislation to do the job that it is purporting to do.
Okay.
Yeah, and I think the way that it's framed currently as well with an inquiry into the reasonable targeted person is problematic, because the focus should really be on the commission of the offence rather than on how it makes the targeted community feel. And what it does is it adds an extra prosecutorial burden, and it means in practice, as we've seen with the civil provisions, that it becomes an inquiry that may elevate fringe perspectives.
Okay. That is very helpful. In general terms, the structure of the bill, it's an omnibus bill. It contains a range of measures that relate to hate speech, hate groups being listed, firearms laws. I mean, would it be the preference of ECAJ to have the bills separated, or you don't mind? To us, given the complex nature of everything we're dealing with here, it was an odd inclusion, but does your organisation have a view?
Yes, we're certainly not experts on gun control laws, and we wouldn't in any way seek to express a view about that in this inquiry. I mean, we're just not qualified to speak. We don't have any particular insight that we can bring to bear that might aid the committee. So conceptually, we see them as two completely different sets of provisions. And so it might be better to deal with them separately, but we don't have a particular view, a hard view on that particular issue, or frankly on anything to do with the gun control issue, because it's not something we feel qualified to speak to.
Okay, thank you for that. Ms Stucken, I just wondered whether the proposals contained in the bill had been seen by the Envoy's office in any way, given the work of the office, prior to December 14 last year.
I apologise. May I ask you to repeat the question?
Yeah, so my question was whether the Envoy's office had seen the proposals like the ones that are contained in the bill we're inquiring into here, or the draft bill, prior to the 14th of December, prior to the terrible day in Bondi last year.
Look, I would suggest, as Peter mentioned earlier, it's best that I not speak to any confidential matters between our office and between the government. Perhaps I could take that question further on notice.
Yeah, but if you could, I guess I'm just trying to understand whether these proposals, so perhaps the question on notice could be when the Office of the Special Envoy first became aware of provisions like these contained in the legislation, as we have it here, the bill as we have it here today, and then that enables us to understand whether these were in contemplation prior to what happened in Bondi, or as a result of. And perhaps I might ask the same question, if need be, on notice of ECAJ as well.
Well, I don't think we need to take it on notice. I mean, we did do a submission to the Senate Legal and Constitutional Affairs Legislation Committee in 2024 on the Criminal Code Amendment Hate Crimes Bill of 2024.
Yes.
And there were a suite of measures in that bill which we commented on. And as I mentioned earlier, conspicuous by its absence was a provision in relation to the promotion of the intentional or reckless promotion of hatred on the basis of a protected attribute. And our submission dealt with both what was in that previous legislation and also what was absent from it. So I think you can, I mean, if you're asking the question about provisions like those that are in the current bill, I think that's the best answer we can give you.
And that was at the end of October last year. So, this was already, consideration of these matters was underway and has been underway over a long period of time. And in that submission, you'll see we put forward what we perceive to be a solution in terms of what potential legislation could look like. And of course, it was not passed.
Yes, of course. And so just on that, I mean, you've provided the submission and it covered omissions as well as inclusions. So are you aware whether, or had you been consulted on a set of provisions that might cover that issue prior to December of last year? You've referenced October last year, but was anything provided to you for your views?
Well, as a consequence of the absence of any similar provision in that 2024 bill, we advocated for the introduction of such an offence, and that ultimately found expression in the bill that was introduced by Allegra Spender MP, I think it was February 2025, and it contained a provision like that, and we are on record as having endorsed and supported the introduction of that provision at that time. So that's a year ago.
Yes. Okay. All right. Thank you for that. My final question I have here, is there any view or any concern held that the bill lacks a specific definition of anti-Semitism or provides any examples that might guide those making decisions adjudicating over matters that might need to be considered? Is there a concern around that? I'm sure you'll touch on it in your submission.
Well, I guess there are two separate questions. One is, should the bill itself contain such a definition? And I'm not sure that would be appropriate because we're talking about a general offence of promoting hatred on the basis of race. A general provision to proscribe the intentional promotion of hatred on the basis of race. So it's not just about anti-Semitism, it's about promoting hatred against any group on the basis of that characteristic. And there are other groups from time to time who would need to be protected by such legislation. So it would be, I think, out of place in the legislation itself to have a definition of what constitutes hatred against any one particular group. Having said that, though, I do think it would be appropriate for police and law enforcement agencies generally to have some guidance about how the provision might operate in relation to the protection of particular groups, including the Jewish community. And in that context, I think it would be very useful to have a definition of anti-Semitism there as a guide. And we're all aware of the International Holocaust Remembrance Alliance working definition of anti-Semitism, which is not a kind of a definitive definition, but an illustrative definition. That's why it's called a working definition, which would be there precisely as a guide and as an aid to law enforcement agencies in working out how to apply the legislation. And in fact, that is the process that has been adopted in the United Kingdom. The Crown Prosecution Service and the police have from time to time published guidelines about what constitutes anti-Semitism for the purposes of enforcing similar legislation in the UK.
Okay. Thank you very much.
Canada has also produced a handbook in which it outlines the application of that definition to what's called illustrative examples, real life examples of anti-Semitism. So there's a lot of guidance out there.
Okay, thank you.
Thanks, Senator Duniam. Now, I understand, Senator MacDonald, do you have some questions? And then we'll have to keep moving along.
Thank you very much. Good afternoon to you all. Thank you for making your time available so quickly today. I wanted to just go back to part 5 and the racial vilification offence. I asked some questions yesterday of the department around in the subsection they classify that the expression of race, colour and national or ethnic origin should be taken to have the same meanings as in the Racial Discrimination Act. I just want to, again, double check that you are satisfied with this as a clarification because, you know, we know that Jewish people don't all have the same hereditary characteristics or whatever. And I just want to be very specific that we're not missing something here and would like your views on it, please, Mr. Wertheim.
Certainly. Yes, it's a fair question. It's one we're asked quite frequently because, I mean, the word race can mean a lot of different things. In past times, it had sort of a biological meaning and was interpreted as you put it earlier, as inherited characteristics. Well, there are, I mean, Jews are not a race in that sense. And despite, you know, Nazi ideology and shocking medical experiments trying to prove to the contrary, they all failed. There is no biological identifier or anything of that nature that would identify Jews as a group. But the word race in the context of anti-discrimination legislation has a very different meaning. It means a group that has a shared past, shared history, shared culture, language, and other ethno-cultural identity that that is accepted both within the group and more generally by other people in society. And in that sense, it has long been established in the jurisprudence of Australia, New Zealand, Canada, the United Kingdom, and the United States that Jews are an ethno-cultural and ethno-religious community in that broader sense and are therefore protected under the rubric of the word race in anti-discrimination legislation.
Okay, so I then extended it in my questions about whether that protection would be applied to other groups and, you know, specifically Christians, Catholics under that group. I mean, you made the point earlier about thinking that this legislation should be expanded to include other groups of inherent characteristics, gender and I'm sorry, I've forgotten the exact list that you used. But, you know, by using this definition, are we allowing for some religious protection and not others? And I'm curious to get your views on that.
Yes, so under this legislation and similar anti-discrimination and anti-hate legislation, Jews are not protected as a religious community, they're protected as an ethno-cultural community. It's a little difficult for many people to understand that the Jewish community is not just a faith community like Catholics or Muslims or Buddhists. We're also an ethno-cultural community with a long national history, a long history of self-government and state institutions, at times state sovereignty and so on. So that Jews are an ancient people with, and our identity is defined in terms that made sense in ancient times and have been carried forward into modernity. It's a holistic identity. It's not compartmentalised between religion on the one hand and culture and ethnicity on the other. And it's for that reason that communities like the Catholic community or the Muslim communities or Buddhists or Hindus would not be covered by the concept of race. They are faith communities pure and simple, and it's a little different for the Jewish people. We don't fit neatly into those other categories, but because of the way that our history is unfolded and the way that our identity is constituted, we do come within the definition of race as an ethno-cultural community, not as a faith community.
So how about if you had a community of people who have converted to Judaism? Are they still going to be protected by that definition?
Yes, because they are part of the ethno-cultural community. And also, as it so happens, if they've converted, they'd be part of the faith community too. But it's not one or the other. We don't compartmentalise between faith and ethno-cultural identity. If you convert to Judaism through a religious process, then you become part of the community in its totality and in every sense. So it would encompass the ethno-cultural, linguistic, the Hebrew language, the Hebrew culture, everything that goes with it would be part of that.
Okay, well, that's terrific. I was keen to understand if you're satisfied with that definition, given that, we're trying to address anti-Semitism in Australia, and I'm not sure that those who are perpetrating anti-Semitism would make the same distinction that you've just made there. So,
Fortunately,
thank you.
Fortunately, the perpetrators of anti-Semitism don't get to mark their own homework or self-assess. It has to be assessed on objective factors, and there is a long line of legal authority, of jurisprudence, and many other factors that establish that the Jewish community in Australia is covered by the concept of race.
And we are making a proposal as well regarding the sentencing aggravating factor as well, to ensure that it includes a mistaken belief that someone is a member of that ethno-cultural group, because obviously a lot of the incidents that we see reported to us involve individuals who have been targeted on the basis of a mistaken belief that they are Jewish.
Okay. Finally, the Prime Minister has used the Old Testament as an example in previous days, and yesterday 3 times he used the Old Testament as an example to justify why he's put the religious text exemption in place. Are you concerned by that linkage?
Look, I think it was a very unfortunate trope. I'm not for a minute suggesting that the Prime Minister would have done that intentionally and with that understanding, but it just illustrates the point I made earlier about the general ignorance in the wider community about who and what the Jewish people are and what anti-Semitism is. And, the Prime Minister is probably just reflecting a much more general misconception and set of ideas by doing that than one might think. Look, every faith community can point to religious texts which have been used or could be used and construed to promote hatred on the basis of race. And yet every single one of those world religions, if you consult the major religious authorities of those religions, will tell you that that is a misreading of those texts. Whether you're talking about the Old Testament, the New Testament, the Quran, or any other religious text, the leading thinkers and figures and leaders of those religious traditions will tell you that that's a misreading of their text, and that whilst some people in their ignorance have misinterpreted them as promoting racial hatred, that is not their true meaning, and in fact it is directly contrary to their meaning. I can point to passages in the New Testament about Jewish people. I can point to passages in the Hadiths and in the Quran about Jews which have been misconstrued in that way. And That's the point of this legislation, where and why the religious exemption is so misconceived, because that's not what the religion says. And where a person uses a religious text as an excuse to intentionally, deliberately, knowingly promote hatred on the basis of race against other people, that should be prescribed, right? Religion should not be an excuse there, because, well, racial hatred in our own time is abhorrent and should not be intentionally promoted under any circumstances.
And we have international law obligations as well in that area. So, there shouldn't be an easy out for any pretext for promoting racial hatred in Australia today.
Was the usage of the Old Testament offensive yesterday? And would you publicly advise that politicians don't use that as an example going forward?
It was ill-advised, and if our advice had been sought about it beforehand, we would have advised strongly against it. And yes, many people in our community, frankly, did take offence. I've had a number of communications about that. But I'm not saying that it came from a malicious or a malevolent place. It's more out of ignorance than anything else, and it's a widely shared ignorance.
All right.
All right.
Thank you very
thank
much.
you for your time this afternoon, and thank you, Chair.
All right, thank you very much. And look, I just wanted to clarify something from earlier. I think it was Simon, you mentioned in your evidence to, I think, Senator Duniam, just about the hate crimes bill and the consultation. You said October last year. I'm assuming you meant October.
Sorry,
2024. Yeah, that's right.
Yes.
I think we all make that mistake in January. That's all good. All right. Well, look, on that note, can I just say thank you very much again to you, Simon, Peter and Anita, especially on the short notice to appear before today's hearing. If you've been asked to provide any additional information, if you could please do so to the Secretariat, ideally by the end of today, just so we can get to work with our report. You'll also be sent a copy of the transcript of the evidence and have an opportunity to request any errors that may have occurred in that transcription. On that note, we'll now break and we'll come back in about half an hour's time, and then we'll be back with the Human Rights Commission. All right, everyone, thank you very much. Welcome back, everyone. Now we'll move on to our next witnesses. Welcome representatives of the Human Rights Commission to give evidence at today's public hearing. For the Hansard record, could I ask that you state your full names, the capacity in which you appear before today's inquiry?
My name is Hugh William de Kretzer. I'm the President of the Australian Human Rights Commission.
Anyone else?
My name is Jewry. I'm the Commonwealth Race Discrimination Commissioner.
My name is Lorraine Finlay and I'm the Human Rights Commissioner with the Australian Human Rights Commission.
All right, excellent. Thank you. Now, although the committee does not require you to give evidence under oath, I should advise that at this hearing it is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses, and given false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And if you asked any questions or notice, please do so within 24 hours of receiving the Hansard transcript. Given the short time frame that we are working within to complete our review, please also answer all questions or provide all information to the best of your ability in today's evidence. Now, on that note, did any of you, or did you have an opening statement, President, before we move on to questions?
Got a brief opening statement.
Thank you.
Thank you, Chair, and thanks to this committee. Chair, the Jewish community has a right to be safe and to feel safe. They have the right to practice their religion, to express their identity, and to live their lives in our nation in peace and safety. Rising anti-Semitism in Australia over the past 2 years has corroded these rights. The Bondi mass murder terror attack shattered them. This bill seeks to implement legal reforms to address anti-Semitism, hate, and extremism. We welcome government action and focus on these issues. We welcome the review of this bill by this committee. We make the following opening comments. We should focus on reforms that will be effective in addressing anti-Semitism, hate, and extremism. Part of this is examining whether existing laws are being sufficiently used, and if not, what barriers need to be addressed. We should protect all communities that face hate crimes. This means ensuring protections cover not only race-related hate crimes, but also hate crimes against people on the grounds of religion, sex, sexual orientation, gender identity, and disability. It is only by addressing all forms of hate that we can achieve social cohesion. We should avoid unintended but foreseeable harmful consequences, and in particular, laws should not overreach. Any limits on freedom of association, freedom of expression, and protest rights must be necessary and proportionate to the aim of protecting safety and addressing hate speech. International human rights laws that Australia has agreed to comply with provide a framework for promoting safety and addressing hate crime while avoiding unnecessary restrictions on other rights. This committee and the Parliament more broadly should draw on this framework in assessing this bill. Laws should be sufficiently precise so that it's clear what behaviour is permissible and what is prohibited, and so that there is consistency in law enforcement. There should be coherence and harmonisation between relevant federal, state and territory laws. These are complex issues which are vital to get right. Allowing only 3 days for this inquiry to review and report on this significant draft legislation is insufficient. It creates risks that the legislation will not be as effective as it should be, or that it will have unintended harmful consequences. Finally, law reform is only part of the necessary response to racism, hate crimes and extremism. The Commission's National Anti-Racism Framework, which we released in November 2024, makes 63 whole-of-government and whole-of-society recommendations to address racism. Many of these recommendations align with the reports of the Special Envoys into Antisemitism and Islamophobia. This framework was based on extensive community consultation and has strong endorsement from civil society. The Australian government has not yet accepted these recommendations. In conclusion, international human rights laws require government action to protect safety and address hate crime. Actions must be necessary and proportionate where they limit other human rights. Human rights principles provide a compass to guide us in taking the right actions to prevent future attacks and promote a safer, more inclusive Australia for all.
Thank you, President. Now, I'll hand the call over to Senator Duniam.
Thank you, Chair. Mr de Kretzer, you referenced in your opening statement there, I think you talked about consultation. Was the Human Rights Commission consulted in the drafting and pulling together of this legislation?
We were consulted after the attack and before Christmas around potential reforms to hate crimes, and we provided some input into some specific issues, but we weren't consulted specifically about this bill.
Okay, so, and who were you consulted by?
Attorney General's Office and the Attorney General's Department.
Okay, and the consultation with the Attorney General's Department, was that on the basis of ultimately developing legislation, or was it in a general sense, how do we respond to this issue?
This was specifically in relation to some issues that received some media commentary around whether or not Section 18C of the Racial Discrimination Act was sufficiently calibrated to protect against racial vilification, and we provided input into that and some broader principles around how best to address hate crimes through both civil and criminal law.
Okay, but the Commission hasn't been consulted on the draft legislation. You haven't been provided a copy at any point and provided input or room for suggestions to be made.
Correct. Apart from those general principles last year.
Okay. All right. Yes, I was asking the department, the Attorney General's Department, about who they'd consulted, but they hadn't mentioned any discussions with the Human Rights Commission, but I can revisit on that with them later on. The
first time I saw this bill was when I was reading it yesterday.
Yeah, sure. Thank you. And have you had a chance to fully digest the 150 odd pages of legislation and 350 pages of explanatory memoranda?
I've fully digest. We've met yesterday as a team, and our analysis is focused on the racial vilification offence, the proposed new offence, the new provisions around banning prohibiting hate groups, and the migration amendments. So we're focused in detail on those amendments or proposed amendments, and obviously the time has been limited in terms of looking at what is a complex piece of legislation that intersects with other existing pieces of legislation.
Yeah, understand. I wonder then if I might ask Ms Finlay whether, and I think this might be in your bailiwick as Human Rights Commissioner, whether the Commission has assessed whether the offence is a proportionate limitation on the freedom of expression in line with the International Covenant on Civil and Political Rights, Article 19 of that, and how it sits with protections of freedom of religion.
Thank you, Senator, and I'm assuming you're referring there to the specific proposed new racial vilification.
Yes, beg your pardon,
offence?
yes. Yeah.
Yeah, and certainly I would agree with President de Kretz's comments about us having read and considered the legislation, but fully digesting a complex piece of legislation, particularly when there are existing laws to consider, international frameworks. Fully digesting is something different to having read and given a preliminary consideration. So I'd just frame our comments in that environment.
Sure.
Obviously, we think it is important to ensure that there are strong laws to address extremism, and there is obviously a need to address gaps in the law in the light of the current environment in Australia. But we do think it's important to do that with reference to the international human rights framework, and particularly to consider whether there are questions around proportionality and whether this law strikes the right balance. So in terms of the new racial vilification offence, for example, we do note that there is reference to hatred as one of the markers, and would refer this committee to the Bathurst Review, which did raise concerns around the introduction of concepts like hatred and whether that introduces imprecision and subjectivity to the criminal law. It's something that needs to be thought through and carefully considered. And in terms of the impact on religious freedom, again, we've had some discussion around the proposed defence that is in there. And it is really critical on the one hand to make sure that we are protecting religious freedom, but also important to ensure that we're actually not using that as a pretext to allow the promotion or incitement of violence. And striking that right balance is something that really does need to be considered in detail, and the specific wording of the legislation is incredibly important, and how it interacts with other existing provisions. And I don't know if my colleagues would like to add anything more, noting this is an area that's in all of our fields.
I'll throw to my colleague Jewry Sivaraman, but I'd make the point that we welcome action on criminalising hate speech. So Australia is required to take action under the International Covenant on the Elimination of Racial Discrimination, Article 4, that requires criminalisation of certain forms of racial hate speech. As you alluded to, the critical thing is getting the wording of those offences right. And there's considerable debate around this. So we welcome that action by government. The government's got a reservation at the moment to that treaty, saying that it's currently implementing that requirement through civil law only. And we think it should also be addressed by criminal law. This action addresses that, but we've got to make sure that it's the right action.
Sure. Mr. Sivaraman, did you...
I think my colleagues have covered it. Thank you.
Sure, no problems. Okay. Well, look, my question was, though, and I think the answer is implicit in what's been said, has there been a proper assessment undertaken by the Commission in relation to that balance? Both Ms Finlay, Mr de Cresta have said that we've got to get it right. That's a future tense expression, which makes me think that the Commission hasn't yet determined whether the balance is right in what is contained here. So I just want to get, if it is the case, I mean, look, we've had this legislation for less than 48 hours as a view, so I would be surprised if you have determined, but if you have, could you let me know?
I can make some preliminary comments, recognising that, I first started reading this complex bill yesterday. It's good that there's a review built into the bill so you can check how this is working in practice. Existing criminal hate speech laws in Australia tend to be rarely used, and there is a range of barriers that need to be explored around why they are rarely used and why police and prosecution agencies tend to use standard summary offences and public order offences rather than specific hate crime offences. And I think the drafting of this attempts to address some of this. Following the Christchurch shooting, the New Zealand government set up a Royal Commission that had a very useful paper around hate crimes, recommended that hate crime should be addressing not only racial hatred but also religious hatred, obviously in the context of an attack around that was driven by Islamophobia, and we support that reach of the racial hatred criminal provisions, that they should be extended beyond race to other attributes such as disability, sexual orientation, gender identity, sex, and religion, in particular when you're thinking about Islamophobia. There's an important question around the standard of whether or not you require intent or whether recklessness is sufficient in terms of the standard of proof or the elements that need to be proved. International human rights guidance, the committee may be familiar with the Rebut Plan of Action, which was a group of UN experts looking at how to implement state parties' obligations under the ICCPR, the International Covenant on Civil and Political Rights, to prohibit certain racial and religious advocacy of national, racial and religious hatred that constitutes incitement to discrimination, hostility or violence. That's an obligation on states. They said that recklessness should not be the standard. It should be intent, so it should be set at a high bar. And so I'd say that that's the right approach here. I think it's consistent with jurisdictions like Victoria with their recent criminal hate speech laws. So those are things that we can say. I know there's debate and controversy around the defence around religious teaching. That's one where we can talk about it if the committee's got specific questions, but that's obviously one of the key issues to be worked through in terms of the Parliament and this committee's consideration of the drafting of this particular offence.
Sure. And look, why don't we perhaps then go to the issues of defence or protection, safeguards, if you will. Has any thought been put into what protections need to be put in place or safeguards to prevent that chilling effect on proper and legitimate debate, particularly as it relates to religion or ideology, national security, immigration, or indeed foreign conflicts. Has any thought with what's been presented here been given to that?
I'm happy to provide my views. My colleagues can jump in after that. Yeah, I mean, we've again, this is the drafting of that defence. I think it's modelled on New South Wales law. I note that the relevant section of the Criminal Code has a general defence around sort of activities done in good faith, like around public discussion or advocacy of around changes to laws and policies and things like that. So I'd say it's good that there are those sort of public interest, good faith defences that apply to this category of offences. And one of the things that we talked about when we looked at this is whether or not that religious teaching defence is necessary, whether it's covered by those broader defences, whether you should look at those broad offences and put a religious defence in there where it's good faith teaching of or discussion of religion as opposed to bad faith incitement to racial hatred. So there's some of the conversations that we've had around this. But yeah, in terms of the sort of criminal standard, the requirement for intent is an appropriately high threshold. The requirement to promote or incite hatred, that draws on the language of the international conventions. And then you have the objective standard of a reasonable person of the target group, if you like, feeling intimidated or fear for their safety.
Okay. Did colleagues wish to contribute to that?
If I could add one thing, Senator, and that is I would certainly agree with President de Kretser around the fact that we've been considering these issues and all of those factors that need to be brought to bear in making that determination about whether the balance is right. But I think it's important to anchor that in the comments that he made earlier about we welcome attempts to address gaps in the existing law to ensure that Australia has robust and effective laws against hatred and extremism. And so our concerns or our thinking isn't so much around the core of what the law is intended to target, but it's really thinking through whether at the extremities of the language that's used, in the detail of the language that's used, there are unintended consequences. And that's analysis that is more detailed and is more difficult to reach a definitive conclusion in the short amount of time that's been available, particularly when it also then involves an assessment of how defences will interact with that. So certainly I would say when you look at something like the New South Wales laws that were introduced, there is good guidance in the fact that there is clear similarities between the provisions, but they're not precisely identical. So understanding what the differences are and if they're material is actually important in the assessment. And then looking at things like the analysis from the Bathurst Review and other reviews that have happened around similar hate speech law reforms is something that is important in terms of understanding what the practical impacts of these laws will be and making sure that we have laws that are not only principled, but that will also be effective, noting, for example, that we do already have a range of hate speech laws and ensuring that those are used to their maximum effectiveness in addition to new laws that might be proposed is an important part of the overall conversation.
Yes, and I want to get into that and that's really the important part. It's the part that left some of us with grave concerns when asking departmental officials about how the laws might operate because, of course, no one has a crystal ball. No one knows what every judicial officer is thinking when assessing a case before them. And so it is that detailed analysis that we need to get our heads around. The last set of witnesses, I believe, referred to a similar defence in Canadian legislation, if I'm not mistaken, which was, or has been flagged as to be withdrawn, taken away because it's a failed exemption, this religious text exemption. So that is one indicator of success or otherwise relating to such a defence. What do we do? What can we usefully do? Because within 7 days, we're supposed to, as a parliament, have passed these laws. What can be done to ensure that freedom of speech or expression, association, is protected in what it is we have before us here?
I think that's a matter for Parliament and for the government. We have said, from our point of view, in analysing this legislation, and we think getting it right is critical, because you want these laws to be effective in addressing hatred and extremism, and these are complex issues, and so the risk is, if they're rushed, that you get unintended consequences, or the law is not as effective as it should be in achieving its aim of promoting safety and addressing hate speech, while avoiding unnecessary limitations on other rights like freedom of religion, freedom of expression, freedom of association, and protest rights.
Senator, could I just jump in and also respond to your question?
Yes.
The first thing is, and I appreciate you put it in the context of what can you do in 7 days, which is not a lot.
Yes.
The first thing is, we think that there is scope for this bill to be referred to other committees for consideration, other parliamentary committees, and that is something that could be warranted to provide further opportunity for consideration and consultation. The second is the defence, the religious text defence, is one which puts the onus on the defendant. So the defendant has to show, as it stands, as the bill is framed, that they meet that defence. And that's because, according to the EM, the defendant would best understand how that text might operate. But what that means is there needs to really be consultation with the people that are the experts on those texts. And there's an additional reason why that consultation is important, because whenever it is that governments increases security, and completely understandably after the shocking events of Bondi, community consultation and engagement is far and away the most effective means of actually improving security across all communities. Whereas if communities are disenfranchised or are given very limited opportunity to engage, then it's not as effective. And the third point I'd make is, in terms of unintended consequences, and again, all of this is in the context of we are supportive of better protection against racial vilification. I'm supportive of that. It is a position the Commission has had consistently in terms of the reservation to Article 4. But understanding how race and racism operate mean understanding and also acknowledging, for just one example, in terms of that you wouldn't want to be in any way caught by the law is, for example, Aboriginal and Torres Strait Islander commitment or demonstration or calling for sovereignty or self-determination. So these are the sort of unintended consequences that need to be avoided. These are reasons why consultation is so significant. Consultation is not just about the outcome, it's about the process, it's about the engagement. I'm so sorry, that probably doesn't actually help you very much in the 7 days you've got, but I believe
Well, no, it in a sense does, because, and the reason I ask the Commission the question, what can be done, I would view this entity as the experts around what could be done. Those of us on this side of the table are merely the instruments to try and get to a point in legislative reform that gets the balance right, and so we're looking for that guidance. The government have set down a time frame. Two of you at least have mentioned unintended consequences, and that is something we are concerned about, because unless tested, you don't know how these things will operate, particularly, as Ms Finlay said before, in concert with other pieces of legislation. Mr de Kretzer has come off mute. Did you have something?
I was just going to offer that we recognise the government's time frame and the constraints this committee is operating under, and we will be as helpful as possible to assist this committee to analyse and make recommendations around this bill. And so our review of the bill is specifically looking at where can things be improved to reduce the risk of unintended consequences and to make it as effective as it can be. And one example for that is when the bill, we welcome the bill taking action around prohibiting hate groups, extending that sphere, if you like, beyond simply terror groups to groups that are promoting racial hatred. That's required by the International Covenant on the Elimination of Racial Discrimination. So that's good that the government is taking action on that. It's important, again, that you get it right in terms of not unduly infringing on freedom of association. One thing in the bill says that the minister who will make that decision doesn't need to afford procedural fairness or natural justice to the group that is potentially being prohibited. And we think that that's an important safeguard that should be inserted into the bill to make sure that, to avoid wrong decisions. We think that the threshold for the lowest threshold for the report from the Director General to the Minister is very low and could be strengthened. So our submission, which will come to this committee tomorrow, will suggest those amendments to try and improve the effectiveness of the bill, because we recognise the time frame, and so we are being practical in looking at this and saying we want to make this bill, if it's going to be passed, as good as possible. And so that's the role we're playing.
But more time would always be helpful, right, in assessing complex legislation?
Specifically in this context, yes.
Sure. Look, just in general terms, I mean, if these laws pass, amended or unamended next week, you'll have community leaders, you'll have speakers, you'll have religious leaders, you'll have journalists wondering where the line is. I mean, how do you think they can go about their business in whatever forum they operate without falling foul of the law and not having to seek legal advice? I mean, because there is a complexity to this intersection between the freedoms that we want to afford people, but the protections we want to give others. How do we try and ensure that we're not in a situation where all of those categories of people aren't having to go off to their lawyer to get advice to ensure that they're not going to find themselves before a court and perhaps finding themselves inside the clink for 5 to 10 years?
Again,
Mike, I start with that. Sorry.
Sure.
The first thing to note is, I can only speak, I'll preface this by saying the only provisions that I've reviewed in depth are the racial vilification provisions in the time that we've had. So my comments are limited to those provisions.
Sure.
But they do have criminal consequences. The first thing is that the concepts are known in the sense that they are, in some senses, the criminal equivalent of what currently exists in Section 18C of the Race Discrimination Act, which has been in place for a long time. And those provisions have been used and litigated, and there is some guidance about them. I appreciate they're not the same, but they have some similarity there. The second is that the community will only know, well, community to some extent, that is part of the purpose of engagement with community, to help them understand how the laws might operate. In some senses, it is not going to be that complicated in terms of if you're advocating for violence, you should be aware that you're advocating for violence, and that's wrong.
Yeah.
I don't think
it'll be in the hard and fast examples that the concerns or questions are raised. I think there will be tests in courts where there will be interpretation in question around what was said, what was meant, was intent there. That's, I guess, what we're getting at, but I take your point.
And to some extent, there is, I think, a capacity for the Commission to assist. We do provide guidance as it stands now in terms of Section 18C and the protections against racial vilification. And we may be able to assist in terms of providing guidance on these provisions should they be passed, including drawing on research and reports that have been produced overseas. So I think there is scope to educate, to engage and to help. There will still obviously be areas that are unclear and that will end up being tested. I think that's also somewhat inevitable. But if we're given the opportunity to, for example, produce resources and to assist, that's certainly something that we would take up. I don't know if my colleagues want to add anything to what I've just said.
I had one observation, Senator, just based on the existing laws that are in place. They're not specifically relating to this new proposed Commonwealth law, but one of the challenges in assessing what law reform is needed in that it isn't always clear what the thresholds are for the existing law in terms of the enforcement of those laws. So understanding why police do or don't decide to charge or why prosecutors do or don't decide to proceed with decisions. Yes. One of the real challenges in assessing the current legal landscape has been understanding where those lines have been drawn, not just on the face of the legislation, but in practice. Yes. And that's something that I think does need to be considered in terms of assessing where the gaps are.
Yes, all of which we need to do in less than 7 days to get it right for the Australian people. Just back to the religious text defence, has the Commission given any consideration to how that might be used or how effective it might be, whether it's necessary or not? The previous witnesses, in particular the Executive Council of Australian Jewry, were saying, in effect, that it could be weaponised, it needs to go. Does the Commission have a view on that element of the proposed bill?
I'm happy to speak to this, Senator. And this is an issue that we've considered. Firstly, I don't think we have a definitive view because it requires consultation with the affected stakeholders. That is the religious organisations that might be relying upon texts. The second thing is that text in itself is a term that how that might operate, particularly with religions that don't have central texts, is a bit unclear. The third is, that being said, it does appear to be narrow in its scope, and in a sense what it is trying to do is a balancing of rights, balancing of a right to religion and religious practice against the right to be free from intimidation, harassment or violence. So we have, our position is that as it stands, based on the limited capacity to digest and consult, that the defence, if narrowly put, is a defence that can still maintain that balancing of rights. But we also see that there will be potential difficulties in terms of interpreting and applying the defence, and that's something I suppose that, and we weren't in the short time that we had able to find overseas guidance on it. I don't think, unless either of my colleagues did, but I don't think in the last 24 hours we've been able to do that. So I'm not sure if Commissioner Finlay, you want to add to what I've said?
Not specifically, no.
Yeah, and so sorry, go on, Mr.
I just had the Christchurch Royal Commission didn't look at this specific issue of this type of defence, but it looked at whether you put a defence into, and they were looking particularly at the a criminal prohibition on religious hate speech, and their view was if you set the threshold for criminality high enough, you don't need the defence. If that makes sense.
Yes.
So there's different options to address this. Good faith quoting from a religious text, no one wants to prohibit that. So you could look at the general defence in, I think it's section 80.3 of the criminal code that covers all these offences, and put in a good faith religious discussion or religious teaching defence there. This obviously came up in the civil context in the case of Wertheim and Haddad, Peter Wertheim from ECAJ bringing the case against Wissam Haddad, and the court gave very helpful guidance around the fact that racial vilification by that particular preacher was not protected, it wasn't in good faith, and it wasn't a teaching of a proper interpretation of the religious teaching of Islam. And so it wasn't protected by the 18D defence, and therefore it was unlawful conduct which brought the civil sanctions. And so there is that guidance to look at in terms of how to frame the defence here. In the 18D context, in the civil context, it's a good faith defence in terms of discussion or commentary on issues of public interest.
Yes, and good faith is something that sometimes is in short supply, but yes, I take your point there. The explanatory memorandum, and we interrogated the officials from the Attorney General's Department yesterday about this issue. They're saying the ordinary meaning of a religious text is the one that ought to be adopted by the courts. I think Mr Sivaraman raises a good point. There may well be, and indeed probably are, faiths that don't have a central text, and that is the test that the officials, the drafters, have pointed to as guidance for the courts. So they are not able to afford themselves of that defence if somehow they get caught up in some sort of action relating to this. So that is another level of concern. Just more generally, as I close out my questions, I wonder whether, and I know you're going to be providing a submission, are there any further specific amendments that you want to give voice to today as guidance for us as we conclude hearings that would help improve this bill insofar as it's able to be improved?
I mentioned before so I've focused a lot on those provisions around prohibiting hate groups, and we think that unless there's a good reason that procedural fairness should be afforded to the group that is potentially being banned, so that they have a chance to say do they or do they not fall within the terms of the relevant provisions. The threshold for the report from the Director General of Security at its lowest level is quite low, so that could be raised to provide better protections. We'll put them in our submission, and they're some of the issues which we're focused on.
No problems. All right.
I just flag one other area very quickly, Senator, and obviously we'll expand on this in our submission, but we have also given some thought to the migration amendments, and in particular, whilst we obviously recognise that it's really important to ensure the Australian government has robust laws and processes in place to allow for the refusal or cancellation of visas where appropriate, the breadth of some of the new provisions, it would be useful to get some clarity around whether, for example, endorsing statements, whether reposting or liking on social media a statement would be enough to enliven that power, whether a risk of harm, whether there's a minimum threshold there. We'll go into some further detail in our submission about some of our queries around that. But in addition, the question of whether, as well as the new powers, the lowering of the threshold in relation to existing powers, so for example, the substitution of might for would, whether that is something that is necessary and would make a material difference. We would like to see some further clarity around what some of those changes actually mean in practice.
Yes, okay. So lack of clarity there is obviously across the board, but that's very helpful. So you say the submission will include references to those further areas of work, and it may mean, of course, we need to again speak to our friends at the department to get that clarity, because again, within 7 days we will have been asked to pass this legislation, and if the Human Rights Commission is asking these questions, they're ones we do need answers to. But I have no further questions, Chair. Thank you.
All right, thanks a lot. Look, I've just got a few more. I'm just mindful that our schedule somewhat has been moved a bit, but I guess the overall view, though, is does the Human Rights Commission then support the intent of the bill? I guess is probably my first question. I'll probably go to you, President De Crezzo.
Absolutely. Yeah. So we strongly support action to address anti-Semitism, racial hatred, and as I've said in my opening statement, we think this should be expanded to address all forms of hatred, and that's critical to ensuring social cohesion in our nation. We haven't, if you look at the international human rights standards and obligations, we haven't properly implemented our obligations to prohibit under criminal law incitement to racial hatred, and this bill does that, and the issue then becomes, so we welcome that, the issue becomes, is it calibrated correctly Similarly, the prohibition of groups that promote or incite racial hatred. It's good that the government is taking action on that. And again, the issue becomes one of getting it right in terms of calibrating that so you're not unnecessarily restricting freedom of expression, freedom of association and other rights.
And with specifically to that prohibited hate group provisions, are there any parts of the provisions that you support or would like to see changed?
I'd only say what I said before, which is that we welcome the regime of extending the prohibition from terror groups to groups that are involved in hate speech. That's consistent with the International Covenant on the Elimination of Racial Discrimination. The threshold, we think procedural fairness should be afforded through that decision-making process, unless in a specific circumstance there's a very good reason why we can't afford procedural fairness. And the threshold at its lowest for the Director General of ASIO to provide that report, which then triggers the AFP Minister's assessment of whether or not to prohibit the hate group, that could be raised because at its lowest it's what might happen in the future, I think is the terminology. Engaged in activities that indicate a risk that the organisation may advocate for politically motivated violence in the future, which is a very low threshold to trigger that report from the Director General to the Minister, and then the Minister's not required to observe procedural fairness. And so we think that can be strengthened that way.
Okay, but otherwise you think there are appropriate checks and balances otherwise?
I wouldn't say that. I'd say our preliminary view is that it's a strong view that this is a good thing that the government is taking action on this. These are the issues which we've identified. We're obviously following the commentary from others and the evidence of this committee, and we'll continue to do that. And we will provide as firm a view as we can, recognising we want to be helpful, but we also want to get this right and recognising the time constraints.
That's right.
Complex, important legislation.
Were there any other parts of the proposed legislation that we haven't covered that you wanted to express any views while you've got the floor?
No, we will continue to work this afternoon and raise any other things in our submission, but I don't know if my colleagues have anything else that they wanted to add in response to your question. No?
Okay. All right. Thank you again for making time to appear before the committee on short notice. If there have been any questions taken on notice, we will no doubt be asking you to do so, provide a response if you can by the end of today. We'll also provide you with a copy of the Hansard transcript. Now, we're just going to now release our witnesses and move on to our next, but in doing so, we'll just suspend briefly and come back. Thank you, everyone. All right, welcome back, everyone. Now, welcome Mr. Michael Pizzullo to give evidence at today's public hearing. For the Hansard record, could you please state your full name and the capacity in which you appear before today's committee?
Michael Pizzullo. I'm here in a private capacity.
Thank you. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing proceedings of respective houses. Given false or misleading evidence is a serious matter, may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. As you may be aware that due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide any information to the best of your ability in today's evidence. Did you have an opening statement at all, Mr. Pizzullo?
No, Mr. Chairman, I don't.
All right. Now, I understand Senator Dunham, you have questions?
Mr. Pizzullo, thanks for coming along today, especially in a private capacity. It's your time you're giving up, so we are grateful. Obviously, people haven't had a huge amount of time to digest nearly 150 pages of legislation, less than 48 hours, plus 350 pages of explanatory memoranda. To your mind, you're a former Home Affairs Secretary, you know a thing or two about the operations of laws within the portfolio and counter-terror operations. Do these proposed laws improve the capacity of agencies, the government more broadly, to undertake counter-terror operations?
Thank you, Senator. In general, they will. There are elements that are cutting new ground, probably in some respects world-leading. As was discussed in the previous session, some of the concepts necessarily are going to be ambiguous and potentially imprecise. Bringing hatred, for instance, in this way into the criminal law, which I support, particularly the schema around prohibited hate groups, which will give the officers who work in counter-terrorism a second lever or a second set of tools to deal with the prohibition of groups, for instance. That will take probably more time to bed down within any bureaucratic system than might sometimes be appreciated. What do I mean by that? If you've administered, as I've had the great honour to administer over about a decade, either customs legislation, elements of taxation legislation, the Migration Act, which is perhaps one of the most, if not the most complex statute that the Parliament has seen fit to pass over perhaps next to the tax law, translating those into operative procedures that officers can actually act upon, that they can defend, either at administrative merits review or in judicial review if the matter gets before a federal court or in the ultimate circumstance gets before the High Court in terms of a constitutional challenge. You really want to make sure that those decisions are not contaminated from the first time they're made. So in terms of developing practice statements, training packages, affording guidance to the officers who will be doing the work, that will be a matter for the Director General of Security within ASIO. He'll have a set of procedures and protocols that he will initiate once the Parliament passes this law, or in some whole or substantially whole fashion as amended perhaps. The Commissioner of the Federal Police will do the same. She'll have to issue guidance to her investigators commensurate with her powers. But so will the Secretary of my former department, the Department of Home Affairs, both on the migration side, translating into guidance, which is all discoverable, of course, and can potentially be brought forward in evidence at either merits or judicial proceedings. That will be a job of work. And in some cases, I would caution those who are in the roles now. I'm just a retired Canberra pensioner, so I'm watching this from afar, or perhaps just down the road, in fact. I would caution an early charge into some of these concepts and operationalising them. I would wait until some of that sub-legislative guidance is worked through. I was heartened to hear the view expressed by some of your previous witnesses from the Human Rights Commission that they stand ready to work with some of the agencies to translate concepts that are, by definition, somewhat more imprecise than terror or violence, when you're starting to get into vilification, hatred and the like, providing guidance that will never be set and forget, because you'll have to keep evolving it with case law and the like, and also changing social understandings of certain concepts. That will take a period of time, and I would certainly caution care in that regard. And one final sentiment that I wish to express, or view that I wish to express that's connected with that: The AFP Minister and the ASIO Minister, as defined in law, currently the Home Affairs Minister, has got particular responsibilities to issue directions and guidance to those two agencies. So he's supported in that role by the Department of Home Affairs, consulting with the Attorney General's Department and others as required. I think getting those ministerial directions right, they're required to be tabled in the Parliament, as they should be. That's another vehicle where you can get this precision at the sub-legislative level that I think it's going to be so very important.
Yes, and you make a good point around, and I did ask the Commissioner of the AFP and, of course, Director General Burgess questions around application of these new laws. And the reason I asked them is because we are being asked to pass within a 7-day period from first sight to last vote these laws. So you're right to point out, after assuming these laws pass, that there is a body of work to be undertaken by those who apply the laws. Can I then just take us back to pre-passage of legislation? You've been on the other end of this. You've drafted or presided over drafting within a department to get certain legislative outcomes. One of the things a number of witnesses, as you'd have heard today, are talking about is unintended consequences. With someone of your experience, do you have any concerns around potential unintended consequences of what it is we have here before us, noting that we have in total 7 days to read, examine, interrogate, debate and pass this legislation?
Senator, look, possibly, but in my experience, whether it was in relation to putting citizenship revocation provisions into the citizenship law or pursuing some very edgy ideas such as continuing detention of persons in jail beyond the period of their conviction, applying extended supervision to such persons after they got out of jail. These are really cutting-edge ideas. There are always going to be... I think this Parliament just simply has to accept you're not going to get perfection in the drafting. I think we've seen that with citizenship revocation, for instance. It's gone down several times in terms of High Court challenges and there's always a process of refining. I think if you set up to achieve the perfect set of provisions, which I'm sure that no senator or member in the House would want to say that they're doing, and you drag it out, there's always going to be something that you will find because some case will be determined, if not next year or the year after or 5 years down the track. And people will then look back at these proceedings and say, oh, if only they'd moved this word here or they'd anticipated that circumstance. If you do that, the possibility is that you'll miss getting the benefits of deploying this legislation with all of those practice arrangements that I've just spoken about, and then you improve as you go. That would be my counsel to this committee. Is there a risk of unintended consequences? Yes, because you're dealing with elastic, imprecise, in some cases subjective notions. So as I said, the more practical guidance you can put underneath the explanatory memorandum and deploy that into the teams that will be actually doing the work, I think that will help reduce the probability of error or the likelihood of consequences that are unintended being effected. And then that leads me to a supplementary point that I was going to make in any event, but I'll make it now. This cannot simply be grafted as a piece of additional work on the current teams that are doing the work. This is the most consequential, putting hatred in at a level, if you like, below terror into our defences, our counter-terrorism defences, is the most consequential and something that I support, I should add, particularly with the listing of prohibited hate groups. It's the most consequential change in this area of law since 9/11. So we've built a body of counter-terrorism laws for over about a 25-year period, but they've all been largely variations on one theme: the idea of terror. What is a terrorist? Yes. What is a terror group? What's the terror organisation? And so on and so forth. And yes, there's been refinements in the criminal code, particularly over the years. This is a different species. It's the next level down, and it's necessary because it deals with what the Director General of Security has called awful but lawful activity. So it's absolutely the right thing to do. We'll still be debating the practical effect, bringing into effect of these measures in years to come, because there will have been court cases, there would have been defences that prevail at trials and the like. if you just simply stretch the teams that are currently doing things like social cohesion, working on counter-terrorism, working on countering violent extremism, and say, look, by the way, there's this additional scheme of work that you're going to have to work on, I think that almost sets the whole scheme up for failure, and you're almost designing in failure. So I'd be, if I was the Minister, particularly for Home Affairs, because I know the package is presented to the Parliament by the Attorney-General, but all the heavy lifting will be done by the Home Affairs Department and the agencies that orbit Home Affairs. I'd be very seriously pressing the Secretary and the agency heads. We want this to work in good faith. What additional resources do you need? What changes to business processes do you need to put in place? What databases and systems do you need to put in place? Because they'll be looking at areas of social life, hatred particularly, that have never had to be examined in any kind of comprehensive or detailed way in a criminal law setting. So it's quite revolutionary in that sense.
Yes. To that end then, what the reforms contained in the draft legislation, are they, to your view, the most important reforms we should be focusing on when it comes to counter-terror in this country?
I've been reflecting on this, and of course we're here because of a catastrophic and tragic occurrence, which might well, through the proceedings of the examination that's going to be undertaken by the Royal Commission, the Royal Commissioner might well form the view that horrific event was tragically avoidable, whether through the strategic failure of how we've designed our counter-terrorism arrangements, or potentially, unlikely given what we know now, but potentially some tactical or operational failure where some particular flag was not missed, was missed rather. You've got, Senator, I think before you, given how you motioned your hand before, a printout, I think, of both the bill and the explanatory memorandum.
That's correct.
I was in this game for a very long time. I can absolutely assure this committee that there is no way that those concepts, those ideas, the passages that have been drafted in with all the footnotes just fell into people's minds on the evening of the 14th of December. There is absolutely no way that that's occurred. So to the extent that these ideas were around, they were in bottom drawers, they maybe had been proposed, maybe they'd been rejected, maybe they'd been not considered by governments of different persuasions or considered and set aside. Are they therefore the most important things we need to do now? I would argue some of them were important things we needed to do 2 years ago.
Yep.
When we heard the cries on the Opera House steps, and I'm going to have to repeat the horrific phrase, kill the Jews, for instance, we should have moved on this front and many other fronts that night. Now, whether in a causal sense, and this is a matter for the Royal Commission, not for this committee, that ultimately would have seen those people not be killed on that horrific evening, is something that's going to vex us until we get some answers to that. So yes, are these important now? Yes, they are. Damn straight they are. But they were also important 2.5 years ago. Why weren't they pursued then?
Yeah, and I think that's a fair question. Peter Wertheim indicated that on behalf of the Executive Council of Australian Jewry that some of these concepts were ones they'd advanced in submissions relating to other pieces of work. So, as a former Secretary of the Home Affairs Department, it's your view that some of these concepts would have to have been floating around in some form well before the 14th because of everything that has been happening and the concepts being advanced by groups like ECAJ and others? You find it hard to believe that all of this, the 500 pages, was drafted between 14 December last year and the 14th of January.
It's just impossible. As fine as our government lawyers are, and they are some of the best in the world, the calibre of the staff at the Attorney-General's Department, the calibre of the staff in my former Department of Home Affairs, they are first-rate public servants. And I suspect they had barely a day off. They might have, in the spirit of generosity, maybe been given Christmas morning off. But with all of that talent, professionalism and brilliance, there is no way that this package, in its form that's presented and sitting under your hand there in that folder, there's no way that could have been developed in the time that's occurred in, what is it, a month today since that horrific attack.
Okay.
And that to me, as a citizen, is telling, because in my mind I'm thinking, well, why has this been rushed now when it should have been staged and put into place at least 2 years ago, possibly before, there's an argument there, but at least after the horrific Hamas attack into Israel, which was always going to generate some kind of, wherever you sit on the merits of the Gaza conflict, it was always going to generate some kind of societal fracturing.
And indeed, that is a fair point. I mean, we are, as legislators, being asked to consider and pass this legislation in a 7-day period. If they're concepts that have been floating around for a period of time, however long, that is concerning, given we are now seeking to, or being asked to pass this legislation, which will have impacts and interactions with other laws that we don't know yet. But look, I will share the call, Chair.
Okay, thank you.
Thank you.
Mr. Basilio, it'd be fair to say, though, these concepts not just been kicking around the last 12 or 18 months, but a bit longer than that. I mean, anti-Semitism has been around for a very long time, sadly.
Yes.
It's fair to say, even during your tenure as Secretary, sure these concepts would have also kicked around.
I've made a commitment, and I know I'm here under parliamentary privilege, but I've always made a commitment to not betray confidences, cabinet or otherwise, of both governments, both types of government that I served. Suffice to say that both in immigration, when I was running the immigration department, the cancellation provisions, which probably are a very, very sensible belt and brace, but some of the cancellation powers that we had were strengthened certainly over the course of about 10 years. This is a better improvement still. But the hate ideas and getting below the level of terrorism, the terrorism listing threshold, I certainly would have loved to have had that over the course of the period when I was Secretary. As to whether it was proposed, as to whether it was rejected, I'm really, you might have to wait the 20 years for the release of cabinet papers, perhaps.
Sure, I guess where I'm going at is I just wouldn't want to have your evidence characterised as an attack on this government, but I mean, governments on both persuasions, you know, have had to deal with these issues.
I agree, Senator, and for me it's not whether it's Labor or Liberal. I don't care who was in power as at the October 23. Whoever was in power, I think there was a particular responsibility that was as plain as the nose on your and my face that things were going to get dramatically worse after Hamas attacked Israel on the 7th of October, and we only needed 2 nights of confirmation before we saw the vile hatred of Jews expressed in front of an iconic Sydney landmark.
Yeah, and as you'd be aware, the government has for some time done a lot of other work too,
Yes.
you know, not just in a legislative sense, but also
Yes.
other levers that it has as a Commonwealth. Now, I think, Ms Clayton, did you have a hand up there? And then we'll move on.
Thank you, Chair. Thank you, Chair. I won't take time. Thanks very much for your evidence this afternoon, Mr Basilio. I'm just wondering, thinking about all those different points in time where actions might have been taken, I just wonder, in your experience, when you were the Secretary of the Department of Home Affairs, there was a decision taken back in 2021, if I recall correctly, to discontinue the task force that had been established following the Christchurch attack. And that was about addressing the online violent extremism, which we are, you know, really putting a lot of thought into how to, you know, it has become, our intelligence agencies tell us how problematic that online extremism has become. So could you step us through what was the reasoning behind the discontinuation of that task force back in 2021?
Ms Clayton, you might have to assist my memory. I'm not familiar. There were lots of task forces around when I was the Secretary. Which particular task force is this?
It was one that was established straight after the Christchurch massacre, and the focus was on online violent extremism. And I don't know why, that's why I was asking you, I don't know why it was under a previous government, obviously, but why that decision was taken to discontinue that action. You know, I don't know if it was thought, anyway, sorry, if you have any recollection of it, it would be good to understand the rationale involved.
I do recall the establishment as a matter of public record. In fact, I think I sat in literally this very chair that I'm sitting in now giving evidence to the Legal and Constitutional Affairs Committee of the Senate. We did set up a number of interim bodies to learn lessons with our New Zealand colleagues immediately after Christchurch. Whether that went for 2 or 3 years, I just can't quite recall. But I do know some of that work then necessarily was, if you like, transferred over with the passing of the online safety legislation and the takedown powers and the work that Ms Inman Grant does. Some of that was transferred to her with support to support her efforts in terms of takedown notices. In some cases, the legislative provisions that we achieved around that time, I can't quite recall the sequence here, whereby the AFP got significant dark web and other powers to monitor online abhorrent and extreme material over and above what they can do with child exploitation material. It might be just simply a function that the task force that was working on, if you like, Christchurch effects or follow-on effects from Christchurch came up with a schema of, and I'm just having to speculate here because I just can't, unless I get the proper name, unless I get the title of the task force, I just can't quite call it to mind. But it might be that the program of work then spliced into different other competencies or agencies that had competency once either laws were changed, regs were changed, or ministerial directions were passed.
Okay. It's hard to imagine in 2026, given the level of concern that we have on online extremism and the idea that we would have somehow not continued that work. So I'd take, we'll do a little bit of following up there, but it seemed, I think, possibly with the benefit of hindsight, we would not have wanted to take our foot off the pedal there in any way, shape or form. And I think it goes to that earlier point that we've got to appreciate there is a long history of extremism, of anti-Semitism, of hatreds that we see, played out now in that sort of, coming to that horrific culmination of a violent, shocking attack at Bondi Beach. So anyway, thank you very much for your evidence today. I do appreciate you giving your time as a private citizen. Thank you.
All right.
Back to you, Chair.
Thanks a lot, Ms Clayton. I appreciate that. Look, I don't think there's any other members that have questions, Mr Pizzullo, so I just want to say thank you again for your attendance today on short notice. If there's been any information that we've requested of you, if you could please provide that to the Secretary by the end of today. We'll also send you a transcript of today's evidence. Okay, well, thank you. Mr. Chairman. Now, we'll move on with our program. We have... I just want to welcome now Mr Chris Merritt and Peter Curti. Is that how I pronounce the last name, Peter? Curti? Yep. Thank you. So from Rule of Law Institute of Australia and the Centre for Independent Studies as the two separate organisations appearing today. Now, for the Hansard record, could I ask each of you gentlemen to please to state your full names and capacity in which you appear today? And I might start with Chris and then Peter.
I'm Chris Merritt. I'm Vice President of the Rule of Law Institute of Australia.
Pete?
I'm Peter Curti. I'm a Senior Research Fellow at the Centre for Independent Studies.
Excellent, thank you. Now, although the committee does not require you to give evidence under oath, I should advise that this is a hearing of the Parliament, and being a legal proceeding, the Parliament therefore has the same standings as proceedings of their respective houses. Giving false or misleading evidence is a serious matter, may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And as stated earlier today, given the short time frame that we are working within to complete our review, please answer all questions or provide information to the best of your ability in today's evidence. Now, did either of you gentlemen have an opening statement you wanted to make, or we can go straight to questions?
Yes, I've got a brief opening statement, if that's okay.
Sure, please.
Well, first up, thank you for inviting me to appear at this inquiry, even at such short notice. It's much appreciated. My organisation, the Rule of Law Institute, is an independent, non-partisan and non-profit body which was formed to promote and uphold the rule of law. The rule of law consists of principles of governance and lawmaking that enable free societies like ours to protect themselves against the arbitrary exercise of power. It gives effect to ideas that go to the heart of what this country is all about. equality before the law and equal protection by the law. This helps explain why the Institute supports the need to change aspects of federal criminal law in order to properly respond to the terrorist attack at Bondi Beach on December 14 last year. That attack demonstrated that there is a clear need to address the culture of Jew hatred that has taken hold in parts of the community. This is why the most important part of the proposed changes is the provision criminalising the promotion of racial hatred. This provision, in Part 5 of the bill, would result in people being jailed for public statements. That's a very big step. Freedom of communication is a fundamental right of citizenship, but none of our rights is absolute, and Parliament has a responsibility to ensure the balance between differing rights remains appropriate when circumstances change. After Bondi, change is clearly needed. Public safety requires a measured but necessary move against one clearly defined form of speech. The death toll from Bondi is the most compelling argument in favour of abolishing the freedom to promote racial hatred. If the goal is to prevent further radicalisation and therefore more terrorist attacks, it is entirely appropriate to target the source of radicalisation, which is the public promotion of Jew hatred. This, however, should not be viewed as a green light for criminalising other categories of speech. The terror attack at Bondi was based on race and ethnic origin, not on sexuality, gender preference, or any other criterion. The new vilification offence is clearly targeted at those who promote racial hatred, but it has a fatal flaw. Its legitimate goal is at risk of being undermined by the proposed offence, which protects those who include a quote from a religious text or even a mere reference. Unless this defence is removed, it would amount to a betrayal of members of the Islamic community who might oppose religious leaders using their position to promote Jew hatred. It would be seen as encouragement for hate preachers who have promoted Jew hatred in recent years by linking their statements to the reading of religious texts. This cannot be what Parliament seeks to achieve. The defence amounts to a guide for hate preachers. It tells them exactly what they need to do in order to continue promoting racial hatred with impunity. Removing this defence would mean that the new offence of promoting racial hatred would apply to everyone. It would be impossible to avoid liability by the simple mechanism of reciting a few words. This requires Parliament to accept that religious freedom, like free speech generally, can be restricted in order to place greater emphasis on public safety. This should not be seen as contentious. The law already prevails over passages, for example, in the Bible, such as Leviticus 20:13, which seeks to impose the death penalty for homosexuality. The point here is that we do not live in a theocratic society. Laws made by Parliament prevail to the exclusion of any conflicting mandate in any religious text. That principle should not be eroded. Now, bearing in mind the time limits, I think I'll leave that there.
Thanks a lot. Now, Peter, did you have an opening statement or remarks?
Yes, Chair, I do have an opening statement, if I may.
Please.
Chair and committee members, thank you very much for the opportunity to address you on this significant bill. I appear before you from the Centre for Independent Studies, where my work focuses on the cultural and institutional foundations of free societies, particularly civil society, liberal democracy, religious liberty, and social trust. And one principal question that guides my research is simply, how are we to live together? I wish to affirm clearly that anti-Semitic violence, intimidation, and harassment are real and corrosive and unacceptable, and that the state not only has the right, but in my view, the duty to respond. However, my concern today is not with the bill's purpose, but rather with its method and scope. The bill is not merely a security response to violence, but represents, in my view, a significant shift in the moral and legal architecture of public life, one that runs the risk of blurring crucial distinctions and, in doing so, weakening both law and society. Liberal democracies traditionally distinguish between three kinds of harmful conduct. First, immoral or offensive conduct, which should primarily be addressed through social norms and the moral resources of civil society. Secondly, dangerous conduct, which may justify monitoring or disruption and prevention. And thirdly, criminal conduct, which justifies coercion, punishment, stigma, and the deprivation of liberty through the judicial process. My concern is that this bill, which I have not been able to study in great depth, but have got a cursory overview of the bill, tends to collapse these categories into one another. And it shifts us from punishing acts to managing risks, from adjudicating harm to preventing possibility, and from regulating conduct to regulating expression and identity. One feature that does concern me is the introduction of status-based aggravation into criminal law, whereby religious officials can face higher penalties, not for doing something different, but for being someone different. The embedding of motive as a pervasive aggravating factor also moves criminal justice away from judging what people do toward judging what they think and feel. And I think this is a profound shift in the character of criminal law. The proposed hate group, the Prohibited Hate Groups regime, concerns me somewhat because whilst it mirrors terrorism law in structure, it extends those exceptional powers to a new domain, the domain of a politically and contested concept of hate. Groups may be listed by regulation on ministerial satisfaction with limited procedural safeguards. Membership and support become criminal where support is so broad that it could capture academic analysis or journalistic inquiry. And I think this moves us from criminalising acts to criminalising association and alignment with heavy executive discretion and limited judicial oversight. The new vilification offence similarly expands criminal law into expression. It criminalises public conduct intended to incite hatred where a reasonable member of the targeted group would feel intimidated or fear violence, with strict liability for the fear element. And this invites subjective or politicised judgments about emotional impact rather than objective harm. My concern is that by over-legalising our response to the very real and troubling problem of anti-Semitism, we may, in doing so, undermine the very thing that we seek to protect. Because anti-Semitism is not only a security problem, it's a moral and a cultural problem. Treating it primarily through criminal law risks weakening the social taboo that makes anti-Semitism unacceptable. And when moral responsibility is outsourced to law enforcement, civic responsibility withers. The effectiveness of law in a liberal democracy depends on its legitimacy, on public trust that it is fair and proportionate and restrained and neutral. My concern on my reading of this bill is that it risks eroding that trust by expanding criminal law into belief, identity, and association, by shifting power from courts to administrators, and by introducing differentiated treatment based on status and motive. So what might a better response look like? Well, first, I think keep criminal law tightly focused on violence and threats and direct incitement, conduct with clear links to tangible harm. Second, if administrative powers are used, they should be applied narrowly and transparently with strong procedural safeguards and judicial oversight. Third, preserve the distinction between what is illegal and what is offensive. Not everything that is wrong should be criminal. Fourth, invest seriously in civic responses, education, civics education, community leadership, and the strengthening of social norms that make extremism culturally unacceptable. And fifthly, include sunset clauses for exceptional powers so that measures adopted in crisis do not become permanent without scrutiny. I would like, therefore, to recommend the removal of status-based aggravations, the narrowing of the Prohibited Hate Groups regime to organisations that directly incite or organise violence, the removal of strict liability from the vilification provisions, and the requirement of proof of intent to cause fear or intimidation, and the strengthening in general of procedural safeguards throughout. The ultimate test of the bill is not whether it appears tough, but whether it proves trusted, not whether it suppresses harmful speech, but whether it preserves the conditions of a free and plural society. The fight against anti-Semitism certainly requires criminal law, but it also requires civic courage, moral clarity, and social solidarity. My concern is that the bill, as drafted, risks weakening all three. Thank you very much for the opportunity to appear before the committee.
All right, thank you very much, gentlemen. Now I'm going to hand the call over to Senator Duniam.
Thank you, Chair. Thank you both very much for your time and for your statements already. Look, I'm going to be brief in my questions. I might start with you, Mr. Merritt. You gave us a fairly in-depth analysis of your view of the religious text defence that has been included in these draft laws. So we'll put that to one side, and a number of witnesses have provided their views on that. Relating to the rest of the bill as it stands, I want to ask both of you generally, and Mr. Curti, you've just spoken about some changes you would recommend, but starting with you, Mr. Merritt, is there anything that could be done to this legislation that would make this something that would remove all of the risks and concerns you have with regard to its application? If it were passed in its current form, how could we amend it to remove those concerns you've raised?
First up, I'd remove the carve-out defence. If that goes through, what we'd be left with is a law ostensibly designed to address hate speech that exempts hate preachers, which it would be ludicrous. That's point number one. But I'm also concerned about the test for liability in the vilification offence, which seems to be drafted in a way that it does not invoke general community standards. It seems to be modelled on the overly subjective approach to liability that is to be found in Section 18C of the Racial Discrimination Act. Now, without getting too technical, in 18C, civil liability is imposed when a reasonable person in the position of those complaining would be offended, insulted, humiliated, or intimidated. It's civil. But under the bill we're now looking at, criminal liability would be imposed when the conduct in question causes a reasonable person who is targeted by the speech concerned, or as a member of the group targeted, to be intimidated, to fear harassment or violence, or to fear for their safety. Now, if the point here is to make criminal liability the test here, it's logical that general community standards should be the bellwether for whether liability is incurred or not. Otherwise, liability would be incurred in different circumstances depending on a range of particular cases, which would make it very difficult over time to look at the body of case of judgments and determine with confidence what sort of speech is now considered to be unlawful. So those two things, the defence needs to go. It's totally counterproductive and is at odds with the clear, legitimate goal of the rest of the vilification offence. And I'd have another look at the test for liability. I think general community standards should be the test rather than whether a reasonable person in the position of the person targeted would feel harassed, etc. Those two changes, I think, would be important. But like Peter Curti, I haven't had sufficient time to go through the entirety of this material. But those I think, are the major changes that I think are needed.
Yes, and noting that, of course, this is 150 pages or thereabouts of legislation and 350 pages of explanatory memorandum. It's difficult to get your head round in 48 hours in any level of detail. So I'm grateful to both of you for your assessment thus far. And just on that test for liability, you talk about general community versus the reasonable person in the grouping. I mean, that's difficult as well for courts, of course, who may not... how does a court determine that standard within a particular grouping if they're not part of the group? I suppose there's a process to go through, but it does add a layer of complexity to this that wouldn't exist if it were that general community standard. Is that right?
Yes, that's my view. I think if you... particularly because we're talking about jailing people, unless it's clear that they've breached community standards, I think it would bring the law into disrepute if it would send the message that breaching the standards of a particular group could result in a prison sentence, which I don't think is what the criminal law is all about. I think it's about the general standards of the entire community being upheld, and I think that's the way the law should be structured.
Thank you. Mr. Curti, you outlined 5 areas of work that would be, in your view, worth pursuing. So in the same vein of questioning, I asked Mr. Merritt, is that your sort of response that those... because not all of it related to the legislation, like civic responses, etc. But if the Senate has, or this committee has before it a draft bill, the Parliament will have before it a bill next week. What's your advice to us? We will make recommendations to the Parliament. What is it you're saying we should do with the 150 pages of law before us?
I echo and support some of the arguments that Chris Merritt has just made with regards to the reasonableness test. I'm concerned about the strict liability test from the vilification provisions, because I think it's important to establish proof of intent to cause fear, where somebody might be found to have committed an offence on the basis of strict liability without having known that they'd even done anything. So I'm concerned about the strict liability provision. I think that procedural safeguards need to be. We need to ensure that there are procedural safeguards to ensure that that the processes of natural justice are not suspended, and we don't lose sight of those principles. I think that the one thing I didn't mention, but I would add now, is that I think there ought to be a 3-year sunset clause with mandatory independent review before the renewal of provisions that are afforded in the bill. I think that I would like to see the narrowing, I think, of the prohibited hate crimes regime, the prohibited hate groups regime. I understand the intent of the bill, and I understand and appreciate the urgency with which the government wants to be seen to act on this set of circumstances. But I think that the prohibited hate groups regime at the moment is wide, and I think it should be narrowed to organisations that directly incite or coordinate violence. And again, I think there should be mandatory judicial review of listing decisions. Those are my principal concerns on my initial reading of the bill.
Yes, at first blush. Noting, again, thank you both for providing that level of analysis with only a day and a half to read it, and it is complex. Mr. Merritt, if you had to start from scratch, what would you advise government to do to address anti-Semitism and Jew hate?
Well, I think the approach taken by David Gonski and now the Royal Commission, focusing on education, civics education particularly, is absolutely critical. If the purpose here is to avoid further radicalisation, we need to get into the marketplace for ideas and argue the case for the principles that underpin democracy, including the rule of law, equal protection, equality before the law, so that vulnerable people, vulnerable young people, and not just young people, new arrivals in this country from places that don't have a thorough understanding of democracy or the principles of the rule of law, so that they are given the weapons they need to resist the push for radicalisation that has clearly taken root in significant parts of society. Unless we're in that marketplace, educating children, trying to head off radicalisation by giving vulnerable people values that they can hold on to as a bulwark against radicalisation, I think we'll lose. You can pass as many pieces of legislation as you like, but unless we win that battle for ideas right at the very beginning, at the border, when new arrivals arrive in this country, and in every school, I think we're still heading for trouble.
Thank you, and that absolutely makes sense to me, dealing with it at the root, I suppose you could say, as it starts. What about, though, when it does come to what's happening now and those in society who might participate in this, but hate speech itself and the hate preachers, what do we do, or how can we tackle what it is that is said by these people in that vein?
Well, I wouldn't delay in getting this proposed vilification offence on the statute book with the changes that I've suggested and with the suggestions coming from Peter Cootie. They all seem very sensible. But I think I've come to this conclusion reluctantly. Before Bondi, I was a great supporter of hanging incitement offences on the potential to incite violence. But Bondi should require a rethink by lawmakers, and it's required me to rethink that view as well. So reluctantly, very reluctantly, I've come to the conclusion that we have no real alternative but to criminalise one discrete category of speech. I'd be very reluctant to go beyond that. There's no case being made for going beyond that. There is a clear case for outlawing racial vilification, Jew hatred in all its forms. But going beyond that, I think I'd be very reluctant.
So when you say one discrete category, you mean in relation to anti-Semitic hate speech, yes? Is that what you're...
Racial hatred generally. In practical terms, that means Jew hatred, anti-Semitism. We're unlikely to see cases of, well, I suppose we might see cases of Hindu hatred or something similar. But the case in point, the real problem that we're confronting, the mischief that needs to be addressed, is anti-Semitism and Jew hatred.
Thank you, Mr. Merritt.
All right, thank you very much. Just mindful of time, we need to keep moving along, but thanks a lot, gentlemen, for your attendance today. And if there is anything that we've requested of you, if you could please provide any answers or information back to the committee by the end of today. We will now move to the Alana Madeline Foundation and Gun Control Australia. And we've got them online. I'd like to welcome as representatives before the public hearing today. Good afternoon. Could I start off with the Alana Madeline Foundation and ask that any people representing the organisation please state your full names and the capacity in which you appear before today's committee.
Thank you, Chair. My name is Sarah Davies and I am the CEO of the Alana and Madeline Foundation.
Good afternoon. My name is Stephen Bendel. I'm the Senior Advocacy Advisor for the Alana and Madeline Foundation. I also convene the Australian Gun Safety Alliance.
All right, and representatives of Gun Control Australia? You're on mute.
I'm Tim Quinn and I'm the President of Gun Control Australia.
And I'm Roland Brown. I'm the Vice President of Gun Control Australia.
Okay, thank you. Now, although the committee does not require you to give evidence under oath, I should advise that that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter, may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And given the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in today's evidence. Now, did either organisation have a brief opening statement? Yes, I see Sarah's nodding. I'll start with you.
Thank you very much, Chair. And I'll read this if that's okay.
Excellent.
But first up, just want to say thank you for the opportunity of appearing before the committee today, and thank you all for stepping in so quickly to consider these really challenging and complex issues. Up front, would like to express our heartfelt thoughts, though, to the victims, survivors and their families, and the responders and witnesses, and all of those impacted by the events in Bondi on the 14th of December. And just say that as a foundation, we know firsthand that the impacts of such tragedy will be felt forever. As you know, we were born out of tragedy ourselves following the events at Port Arthur in 1996, and we were all stunned by the egregious act of terrorism. We understand that the Combating Antisemitism, Hate and Extremism Bill 2026 is a large omnibus bill, and it covers many dimensions aimed at responding to the tragedy. We're here today representing the Foundation and the members of the Australian Gun Safety Alliance, and will restrict our comments to the issues of firearm reform that have been outlined in the bill, because that is our area of expertise. And while we are focused on reducing firearm violence in Australia, I do want to reiterate we have said and continue to say that most legal firearm owners in Australia are good law-abiding people. However, the use and possession of firearms in Australia is universally recognised as a privilege that is utterly conditional upon public safety. Australians have rightly been proud of our gun laws for nearly 30 years. We know that death from firearms has halved since 1996, and I think we all feel deeply grateful that we do not experience the firearm chaos that condemns US gun law policy. However, we have become complacent to the issue of firearms, and over the 3 decades since the Port Arthur tragedy, our gun laws have not kept pace with changes in firearm technology, shifts in ownership patterns, and the unrelenting pressure from special interest groups. We must recognise that gun technology has advanced significantly, and reforms like this are actually long overdue. We have to stay on top of modern gun design and any loopholes which threaten the safety of Australians. So there are now more than 4 million registered firearms in Australia, with around 1 million people licensed to use one. And it's also estimated that there are about up to 500,000 unregistered firearms. New South Wales is the only jurisdiction in Australia where we have any information about where the firearms are kept. And in New South Wales, we know that 60% of licensed firearms are in suburban streets. And until the New South Wales reforms at the very end of last year, WA was the only jurisdiction that had a cap on the number of firearms any one person could own. And we know in New South Wales there are a few individuals in suburban areas who legally own over 200 registered firearms each. So the Foundation supported the New South Wales Premier in his rapid response to introducing firearm reform, and we strongly support the reform package presented to the police ministers last Friday. There is nothing in these reforms or this bill that prevents a farmer, a primary producer, a sporting shooter or a hunter pursuing their job, their profession or their hobby. But the Australian community expects tougher background checks, restrictions on the types of firearms that, like those used at Bondi, and limits on the number of guns that someone can own, as well as tighter importation regulation. These are all entirely reasonable firearm safety laws that the public expects from their governments, And in fact, recent polling shows that over 90% of all Australians, regardless of where they live or their political persuasion, expect and want reform. So regarding this bill, we strongly support legislation that will do the following 5 things. Enable a national buyback of prohibited and unwanted guns. Provide for stronger background checks, national checks, including greater information sharing between ASIO and ACIC. Strengthening customs regulations for firearms to create a new public safety test for the importation of firearms. Treating gel blasters as firearms on importation. And creating offences which are aimed at disrupting the process of 3D privately made weapons and firearms. So just to conclude, in 1996, there was a courageous and uncompromising bipartisan agreement and approach to gun reform. It was a policy position that has served Australia incredibly well and a strong legacy to all of those involved at the time, including our founder, Walter Mikak AM. So we stand with all our national leaders against hate and violence. And as per Walter's plea to then Prime Minister Howard in 1996, we ask all leaders in this House and those around the country to be bold, act now. So please bring our national firearms laws up to date to reflect contemporary technologies and capabilities and to meet the expectations of the vast majority of Australians. Thank you, Chair.
Thanks a lot. Now, I understand, Mr. Quinn, you had an opening statement or something to say? Is that right?
I do.
Oh, sorry.
I do.
You do. Thank you.
I do. And I echo many of the things that Sarah said here. So, Chair, members of the committee, thank you for the opportunity to appear. My name is Tim Quinn. I'm the President of Gun Control Australia. Appearing with me today is Roland Brown, the Vice President of Gun Control Australia and a long-standing legal advocate for strong firearms regulation in Australia, with more than 30 years' experience in the field. Gun Control Australia is a member of the Australian Gun Safety Alliance. As with our colleagues at the Alana and Madeline Foundation, we wish to acknowledge the victims, their loved ones and the many others impacted on 14th of December. Australians from all walks of life should be free to gather, celebrate and practice their faith without fear of violence. Gun Control Australia has worked for more than 3 decades to support evidence-based firearms regulation. Our focus has always been on public safety, reducing the risk of gun violence through practical, proportionate law reform grounded in evidence and experience. Australia's most modern gun safety framework was shaped by the national reforms that followed the 1996 National Firearms Agreement. Those reforms marked a decisive national moment, recognising that firearms regulation is fundamentally a matter of public safety and a firearm licence is a privilege, not a right. The results are well documented. Firearm deaths fell sharply. Mass shooting events with semi-automatic rifles and shotguns were effectively eliminated, and Australia proudly became the global benchmark for coordinated, effective gun regulation. However, those reforms are now nearly 30 years old. Developments in firearms technologies have meant that firearm capable of inflicting mass casualties are widely available on the market, and regulatory settings across jurisdictions have gradually diverged. As a country with open internal borders, our national gun laws are only as strong as those of the weakest state. Gaps have developed across states, and a lack of a national body charged with oversight of our gun laws means that this has gone unnoticed by the Australian public, the very people whose safety these laws are supposed to protect. The result is a growing gap between Australia's gun safety objectives and the regulatory reality on the ground. It is in that context that Gun Control Australia welcomes the firearms measures contained in the Combating Antisemitism, Hate and Extremism Bill of 2026. The National Gun Buyback Framework strengthened background checking, improved informational sharing, and tighter controls on the importation of high-risk firearms and components are important and timely steps. Together, they modernise key elements of Australia's firearms framework and address risks not fully contemplated when earlier reforms were enacted. We also wish to make clear point about background checks. They are an important safeguard, but they are not sufficient on their own. Many perpetrators of mass or ideologically motivated violence are lone actors with no prior criminal history that could prevent them from passing a background check. For that reason, background checks cannot substitute for limits on the types and quantities of firearms available. Australia's success has always rested on regulating who can access firearms, what firearms are accessible, and how many are in circulation. Our support for the firearm regulation component of this bill is clear. We see it as a continuation of Australia's long-standing approach to firearm safety rather than a departure from it. At the same time, Commonwealth legislation can only be as effective as its implementation across states and territories. The success of previous reforms depended on national coordination and consistent follow-through. This bill will be no different. Our evidence today and submission focus on ensuring these measures are supported, implemented rigorously, and reinforced through consistent national cooperation. In closing, Chair, Australia's experience shows that thoughtful, evidence-based firearms regulation saves lives. This bill is a necessary step to closing existing gaps and ensure our framework keeps pace with contemporary risks. We urge the committee to support its passage. Thank you, and we're happy to assist the committee with any questions.
Thanks a lot, Mr. Quinn. Now, I understand Susan McDonald. Senator McDonald, do you have questions?
Thank you very much, Chair. Thank you both, Ms Davies and Mr Quinn, for your opening statements. Mr Quinn, if I could just start with you and ask you what data you have on gun crime, and I note that you've made the commentary around the gun reform legislation in 1996, but in that period, what's your data on gun crime that we're seeking to solve here?
My understanding is that in that time since 1996, we've halved the amount of gun incidents and gun deaths, and that is something that Australians widely support. So we should be focusing on improving that and bringing our standard up to what technologies we currently have in the gun market, so that Australians are able to stay safe and we can continue to bring that number down.
Sure. No, I was just hoping that you might have had some hard data on what the rate of gun-related crime and fatalities were, so that we could understand what's the problem that we're seeking to solve with this legislation. But do I understand correctly you don't have that data?
I don't have data in front of me, but we do have that available through some reports that we've produced recently, which can be provided to the Council Committee.
That would probably be a good idea or notice. Mr Quinn, how do you see the legislation, the legislative changes that are being contemplated, that would have prevented or reduced the impact of the awful massacre at Bondi Beach?
There's a proliferation of guns in Australia. We've got more guns in Australia than...
I'm sorry, just more tightly, I was just asking about how this legislation would have had an impact on the terrible incident at Bondi Beach recently.
I believe it would have significantly reduced the chances of it happening. We have...
let's tease that out a bit, because we do have in place legislation and process that would have allowed for those guns to be removed. All of that is in place currently. The types of weapons, the number of weapons would not have been restricted. I mean, it's my belief anyway that this is a process failure, not a failure of the legislation. Can you point me to somewhere that would, would correct that?
Senator, if I may?
Mr. Bendel.
Bendel?
Bendel.
If I may, in this particular bill, there's quite clear aspect about the greater sharing of evidence or intelligence between agencies. We're yet to understand because the coroner the investigation hasn't been undertaken, but preliminary information was that there may not have been adequate sharing of information, and we know one of the perpetrators had previously been investigated by ASIO. So that's a potential opportunity that should be reduced by this particular legislation. Other legislation changes, such as being introduced in New South Wales, includes the restriction of the types of firearms that were freely available to licensed firearm owners, such as the perpetrators we saw. And as Ms Davies mentioned earlier, the growth in technology of firearms, such as rapid fire, high velocity technologies that weren't identified or considered 30 years ago when they were to be restricted as a Type A or Type B firearm, which is relatively easy to get, as you I'm sure know. And so restricting those would have prevented the access of those. Potentially in other jurisdictions, if I may, limiting the number of firearms available to people in suburban cities may also have restricted the availability of those firearms to those particular perpetrators.
Well, I don't believe that the number that's been legislated in New South Wales would have affected that. So
we'll never know,
I'm
Senator,
concerned because we have, I guess I think we're looking at a belief from Australians who don't hold a gun, aren't interested in guns, that somehow the rest of the community who does enjoy gun ownership uses specific types of guns for whether it be their work or their recreation, and that they should be, those lawful gun owners should be restricted in the same way that I don't need to own a lot of cars or a lot of watches. Other people do. I don't resile from them wanting to do that. But why are this legislation as it stands, I'm just trying to understand how it would have prevented that terrible incident at Bondi or others that, what is the harm that you would seek to minimise?
If I may, this legislation does not include a single restriction on any of the people that you've just identified as potential firearm owners.
Well, I think it does. It would reduce the number of firearms that they own.
Sorry, this legislation won't...
this legislation won't do that.
This is thank you, Mr Brown, for intervening there. This is the framework for an additional round of reductions of firearm ownership that we've yet had a demonstration about what the benefit that would be. We've not had the Royal Commission yet. This seems to me to be a very emotional response. I cannot get data on what the gun crime is, the rates that this would reduce.
There's plenty of data.
Just an anti-gun piece of measure, isn't it?
Senator McDonald, just hang on a second there. Sorry. I just want to get a bit of order here because I know people are online and it's just with delay, but can we just get a bit of transparency and order here? So, Senator McDonald, you've asked your question. Please allow the witnesses to respond. Stephen?
I'm sorry if you thought I was interrupting. I was trying to respond to
well, there have been a couple of instances where I haven't interrupted, but witnesses...
Hang on.
Just hang on. there have been a few instances where witnesses have tried to respond and you've cut them off. So can we just please let them respond? I'm mindful of time. So Stephen, did you want to respond, please, back to the Senator, and we'll continue questions and answers.
I take some, as Ms Davies said, we have never been anti-gun. We have never said that we want to demonise or feel that any legal firearm owner is not able to go about their sport, hobby or job or profession. However, we don't think that 5 or 6% of the population who actually use firearms should dictate how the other 95% of the Australian population feels about firearms. And I understand that the firearm industry is quite concerned about this, but nothing in these reforms, nothing in the New South Wales Premier's reforms, nothing in the reforms that were given to the police ministers last week actually stops anyone from using a firearm. It may require further background checks such as this. It might make it harder to import a firearm, but they are all reasonable restrictions that the vast majority of the population feel is how firearms should be managed.
Thank you, Chair.
Okay, thank you. Now, Mr Quinn, I think earlier you were trying to say something else. I don't know if you needed to conclude your answer to an earlier question.
I don't need to.
Okay.
I think Roland had something to say.
Mr Brown, and then I'll hand the call to Senator Grogan.
Yes, thank you, Chair. It's a misconception to say that this legislation before this committee that's to be introduced into the Commonwealth Parliament is going to change firearm laws around Australia. It's not. It's going to facilitate background checks, and it's going to put in place the machinery for the buyback of those weapons that are going to be handed in or declared illegal or are unwanted throughout Australia. Now, that can only be a good thing to reduce the number of firearms in Australia. The background assessment that's going to be undertaken if this legislation is passed by the Parliament is an excellent tool in the armoury of police and others who have the responsibility to assess who is a fit and proper person to have a firearms licence and to have firearms. But of its own, it's not enough, and this all depends on the states agreeing to change their laws to improve the licensing requirements, as New South Wales has done, to limit access to rapid reloading firearms, which again will be really important in reducing the risk to the community. And as far as the evidence goes, one really important piece of evidence that's often overlooked is this. After the Port Arthur massacre in 1996, we saw a ban in Australia of semi-automatic rifles and shotguns. Those were the weapons that the perpetrator had at that time. And since they were banned in Australia in 1996 and 1997, we have not had a mass shooting with those prohibited firearms. But we have seen in Bondi a mass shooting with guns that are lawful and can rapidly be reloaded. So they're the challenges ahead for the states, and we call on all the states, including Tasmania and, of course, the Northern Territory, come on board and support this initiative. Thank you, Chair.
Well, I've got you. Before I hand it to Senator Grogan, I mean, what are your thoughts around, as I understand it, 3D printing of guns? I mean, you've got some thoughts about the importation or the making of such things here. This is sort of new technology. And any thoughts around what we can consider to better regulate the use of such guns or firearms?
Sorry, was that question directed to me, Chair?
Yeah, look, yes, given that you last spoke, but I mean, really as a broader question to all witnesses before us at the moment.
Well, I'll lead off on it. Currently around Australia, there are prohibitions on manufacturing of firearms, and that may or may not pick up manufacturing by 3D printing. But either way, we'd like to see 3D print images prohibited, and we'd like to have a prohibition on people using 3D printers to manufacture firearms. We don't need that. We don't need that, and we need to have tightly controlled firearms in this country, and the manufacture of them also needs to be tightly controlled to ensure the highest standard of public safety.
Sarah, I don't know if you wanted to add anything there.
Thank you, Chair. Look, just really want to reiterate what Roland just said. We know that privately made weapons and 3D printing is actually a major global challenge. It's not just an Australian issue. The technology facilitates so much more than anyone could have ever kind of conceived back in '96 when the National Firearms Agreement was put in place. I think there are one or two states that prohibit the transmission of the instructions and the kind of templates for 3D printing of weapons, but it's a new space that law and order agencies globally are struggling with. I know that the federal police is connecting across all the police forces in the states and territories to really look at how they can intervene. I think we're just at the beginning of trying to understand how we can absolutely kind of safely manage the risks and harms that privately made firearms deliver. And I'd also just like to say, Chair, we absolutely acknowledge that the difference in jurisdictional authority between the federal government and the states and territories around gun safety and gun laws is complex. And so there is no one that there's no one jurisdiction that's got the whole suite of responses. And so that combination of trying to marry it together between federal law and state and territory law, we understand that is very complex and makes this stuff much harder.
Yeah, appreciate that. Okay, now Senator Grogan, and then we'll move on with the program. Senator Grogan.
Thank you. I had wanted to ask you some questions, but your evidence has been very fulsome, and you've covered a lot of the issues I had wanted to explore with you. But if I start with you, Mr. Quinn, you made a comment, I know you've made this comment publicly, that Australia's gun laws are only as strong as the weakest link. And earlier in your evidence, you said they're only as strong as the weakest state laws. And I know we've just been through this. It is one of the most challenging points to reorient, to ensure that we have a comprehensive, across the board, rules-based order, so that we have consistency. Do you have any ideas about how we might bring that to bear? Because we're all, we have some pushback from some of our state colleagues on some of the elements of the buyback, certainly, and obviously some of our parliamentary colleagues are concerned about that as well. So in looking particularly, because I think you've covered a lot of the rest of it, the buyback scheme, how do you see that working in an effective manner?
Well, I think it has to be, I can't say mandated, but it needs to be led by the federal response. And we need to make sure that we're bringing each of the jurisdictions along in the manner that they need to be brought along. I understand that Tasmania has different issues to it to what Northern Territory does, and I think that the way that you bring them along is through encouragement. We need to make sure that there's strong leadership at the federal level, and I think that there's a question around whether there is a body that helps us manage that and brings the response together that from the federal thing and acts as an advisory body to the states.
Can I come in there, Chair, and add an answer to that?
Sure.
Is that okay? Thank you. Senator Grogan, your question raises a very important point, and I'll answer it by reference to storage requirements across Australia. Up until 2011, the Institute of Criminology used to produce reports annually on gun theft in Australia. I think they were annual, but anyway, unfortunately, the government at the time cut the funding for them. But their last report pointed out that the number of guns being stolen across Australia that was stored in accordance with the regulations was very significant. And they made the point that it looked to them that it was time for an improvement in the standards for storage of guns across Australia, because the uniform standard that was brought in 1996 was just not fit for purpose anymore. We then had Tasmania move, I think in 2015, and brought in some pretty good storage requirements because there had been such a large number of gun thefts in that state, including instances of thieves just walking out with the entire gun safe full of 20 or 30 or 40 guns, and it was not uncommon. So Tasmania brought in some good requirements. For example, for storage of more than 10 guns required security monitoring. And so Tasmania had the better gun storage requirements. But any other state that has the weaker requirements means their guns are more readily stolen, and then they just go into circulation around Australia. So what is necessary in our view is a national committee that oversights the way gun regulation is regulated across Australia and enforced, and how effective it is, so that it can feed back to the national government, who can steer the states in the right direction. Because at the moment, I'm afraid we've seen a bit of a race to the bottom with the gun lobby trying to get each state government to weaken its laws. And we've seen that in Tasmania, and we've seen it in New South Wales as well. So that's our answer to that question, is a national body that can properly review and ensure compliance and efficacy in those gun laws.
Thank you. Ms Davies.
Thank you, Senator. If I could just build on that, it's absolutely essential, because the federal legislation is the one that's able to set up the infrastructure for a national buyback program, and the Department of Home Affairs and the Attorney General's Department are all across what that can look like. We've done it before incredibly successfully. The need for it is really significant, because we now have, for example, in New South Wales, a legislated limit on the number of firearms that any one person can own. If it's related to their profession or their job, the limit is 10, otherwise the limit is 5. Now, we know that there are many people in suburban New South Wales who have 200-300 plus firearms. So there is going to need to be a safe and rigorous mechanism to get those prohibited weapons out of the community and out of risk. So we know that the guns that will be surrendered or voluntarily surrendered and put into a national buyback program are the ones that are unwanted. Well, we certainly, if no one wants them, we certainly want them off the streets. And or they're prohibited. Prohibited because the states and territories have a limit on the number of firearms, or prohibited because we update the classification based on the technology of guns.
Yeah.
So the guns that were used in the Bondi tragedy didn't technically exist 30 years ago, but they operate as a semi-automatic would operate with the multiple reloading. So we have to stay on top of the technologies. So absolutely, we think it's essential.
Thank you. And there's nothing in this legislation that would limit a farmer or a rural property owner from having a gun for legitimate purposes. Is that your...
No, absolutely nothing. No,
that's what...
Not at all.
Okay, thank you so much for coming along, and thank you so much for all the work that you guys have done on this really, really critical aspect of gun control. Thank you so much. Thanks, Chair.
All right. Again, just want to say thanks again for your attendance today on very short notice. I appreciate your understanding given the timeframe that we are working within. We are now going to break. We'll probably break for about 10 minutes for our afternoon break, and we'll come back at 3:35 with Equality Australia. All right, welcome back, everyone. Thank you for the very brief moment there. I'd like to now welcome representatives of Equality Australia to give evidence at today's hearing. And for the Hansard record, could I ask that you state your full name and the capacity in which you appeared before today's hearing?
Good afternoon. My name's Heather Corkill. I am the Legal Director at Equality Australia.
Good afternoon. My name is Sanjay Alapakam, and I'm the Legal Policy Advisor at Equality Australia.
All right, thank you. Now, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, did either of you have an opening statement or brief comments to make at the start, or we'll go straight into questions?
Yes, I actually do have an opening statement I wouldn't mind giving. So
yes,
thank
please.
you so much for the opportunity. I just wanted to start by acknowledging the traditional custodians of the lands on which we're joining from. In my case, it's the Yagara and Turrbal people here in Brisbane, Meanjin. And certainly in the context of laws that are addressing racism, I think it's critical to acknowledge how much further that we need to come as a country to promote the human rights and self-determination for our First Nations people. So Equality Australia is a national LGBTIQ+ organisation that works to promote the rights of LGBTIQ+ people and their families. Just noting the disjointed order in which this process is proceeding today, usually you'd have the benefit of our submission beforehand. To confirm, we are working on one together with at least a dozen LGBTIQ+ organisations. It's a growing coalition at the moment, and we will have that submitted by deadline tomorrow. Overall, we're deeply concerned that the bill fails to protect our communities in key respects. The new offence of promoting or inciting hatred and the aggravated sentencing provisions apply only to race, leaving our community without equivalent protections from hate and violence. And this does come, unfortunately, at a time of escalating hostility towards our communities worldwide, and that includes in Australia too. We recognise the bill responds to the horrific Bondi attack. We strongly support robust protections for Jewish communities, rejecting racism and ideologies of racist superiority in all forms. In this climate, stronger action is needed to address hate speech at an earlier stage rather than waiting until it does escalate into terrible acts of physical violence. We've heard as a justification for not including our communities in this bill that it's a narrow bill only addressing anti-Semitism, but hate causes serious harm wherever it's directed, and the law should offer equal protection under the law to all communities at risk. LGBTIQ+ people have long been targeted by religious extremists and neo-Nazi ideologies and continue to face a serious and ongoing risk of harm. By way of example, just in the last 2 years, we've seen neo-Nazis marching in our streets, targeting our communities, holding banners like "Destroy Pedo Freaks." We've had to cancel many of our community events due to threats, including bomb threats. Extreme violence has been perpetrated against gay men through dating apps. And we also see targeted online abuse, doxing and threats, particularly against high-profile gay and trans people, both online and offline. These laws need to protect a broader range of people, both now and into the future. We need to look at what these laws will do in 2 years, 5 years or 20 years' time. They shouldn't exist only to respond to this terrible and unprecedented tragedy, but should also act to prevent the next one. The very criminal laws being amended by this bill already recognise LGBTIQ+ people as at-risk communities alongside women, people of faith and people with a disability. We fought for this inclusion federally just a year ago, and some states and territories have had protections against vilification for our communities for decades at this point. But the state protections, unfortunately, are patchy, and we need national leadership at this time. To now split and fracture these protections only 1 year after recognising our communities at a federal level is a position that Jewish leaders have rejected, and frankly, it doesn't pass the pub test either. The bill contains inconsistencies in how our protected attributes are treated, which risks sending a confusing message about the law's intent and creating real problems for enforcement and policing. The inconsistencies are threefold. Firstly, the legal uncertainty and enforcement challenges. As I've mentioned already, the unequal protection, which may signal some forms of hate are taken less seriously than others, and a failure to recognise intersectional harm where people may be targeted on multiple grounds at once, such as because they're both Jewish and gay. We really need the time to get these laws right. Hate speech laws require particular care and attention to get the balance right. And in that context, the consultation on this bill has been wholly inadequate. LGBTIQ+ people, community groups, along with other affected groups such as people with a disability, were not consulted on the exposure draft and were just given 2 days basically to respond to this bill. Nonetheless, we know how critical this topic is for our communities. We hear it from them time and time again. And so we do appreciate the opportunity to be here today. We'd be very happy to explore any of the details within the bill further and respond to specific questions if you have any. Thank you.
All right, thank you very much. Now, Ms Clayton, I think you have some questions to kick off. Thank you.
I do. Thank you, Chair. And thank you for that opening statement. And of course, the work that Equality Australia does, your tireless advocacy on legal policy and communications issues generally. It is important work, and I appreciate we're all operating with very short timeframes right at the moment. So thank you for responding so swiftly. I've got a few questions. I might just begin with, I understand from some of the public commentary from Equality Australia already that you've got concerns around framing the vilification provisions. You've reiterated that, I think, in your opening statement, so I'm not verbling you in that respect.
No.
And so I'm just trying to, I think, maybe we'll drill down to some of those reservations kind of now, where we can, and then I'll come back with some sort of follow-up questions, I think, there. So maybe if you could just map out for the benefit of us, given you've only seen the bill recently, and I appreciate that, and you're making a submission that you will put forward to the committee in the next day or so, so we'll have more detail there. But can you just map through some of, what you see really around how the expansion of those vilification laws perhaps, and any consequences you might see of those as well? Yeah.
Sure. Well, I think there's symbolic consequences and there's practical ones. Yep. So one is, as I've talked about, not having equal protection of the law, sending potentially a dangerous message that the government is more concerned about certain types of hate over others. So there's that. And then we just think, well, if we just sort of keep layering these complex criminal laws over the top of one each other, and we create more and more inconsistency, even internal consistency in this one bill, that doesn't help policing and enforcement whatsoever. And that includes for our Jewish communities as well. Because what we often hear about is people trying to report these kind of crimes to their local police station, being met with police who don't necessarily understand much about hate speech laws. They're really complicated as there is. Why are we sort of adding in that inconsistency which has already existed? As I said earlier, we do need that federal leadership on this issue. In terms of obviously we're not part of the racial vilification offence, but this being one of our core campaign areas, we've done a lot of thinking about what we think it should look like. So I can provide some suggestions about how it could also be strengthened, whether or not we are included within the scope. One, I think, is that it could be clearer about acknowledging where there's a course of conduct. So oftentimes we see hate speech as in a cumulative way where it will often be escalating, and it's actually a series of incidents, and it's really unhelpful sometimes to isolate one phrase or paragraph and say, is this hate or not? It's often not the reality of how hate speech works. So we think a formulation from the Victorian law about clarifying that hate speech can be a single occasion or can be a number of occasions over a period of time would improve the drafting. We also have some thoughts on the religious text offence. I know it's been talked about a fair bit already today. We think one of the problems lies in the term otherwise referencing a religious text. We don't have major concerns about where there's a direct quotation from religious text, and I actually don't think this provision is going to have a lot of work to do if you've got to have intention anyway, which is really a point I think earlier made by the Executive Council of Australian Jewry. But if we do retain it, this otherwise referencing needs to be tightened, because the meaning, I think, according to the explanatory memorandum, is not supposed to be the type of referencing which is to mention or allude to something, but rather is to sort of cite a passage. Now, if it's supposed to be about citing a passage of religious text, that might also be okay, but there's no definition of reference, and we can't necessarily rely on the interpretation in the explanatory note. So I think one of our points would be to ensure that we tidy up any sort of really vague language that might weaken the offence. Those are kind of our core suggestions in relation to the racial vilification offence that, hopefully will also get expanded to include other attributes.
Thank you. And I know you referenced, I guess, some of the sort of rationale that you've been provided in terms of the constraints of this bill. I'm just wondering how one of the great challenges is always trying to balance and resolve competing rights and interests in all pieces of legislation from time to time. But I'm just wondering, do you think there is any risk at all from your point of view, expanding the vilification offence to be more inclusive? Can you see any risks at all?
I think if you expanded it without limit or without real careful thought, yes, there's always a problem there. And I think there was a discussion earlier as to should it include inherent attributes? Should it include, certain types of attributes? I think that the better framing is actually who are the groups where there's evidence, there's clear, obvious evidence that they are historically disadvantaged or minority groups that are targeted by hate speech. If there's evidence of that, then you meet the threshold, then you're in. I think it's as simple as that. That process has already been done, though. That was the changes that were made at the start of last year, where we expanded to recognise that it can happen to women, to people with disability, to minority religions such as Muslims. I don't think that there's anything particularly controversial in continuing with the list, as currently is included in the very criminal law that we're now attempting to amend and strengthen.
And I appreciate you're going to put a submission in to us for it, but I'm just wondering if you'd had any thoughts around the provisions of increased penalties. I'm thinking here, there were various sections where there will be increased penalties, and I'm curious whether you think that there is, what your views might be on that to begin with.
We don't think that increased penalties are a silver bullet. Particularly where you've already got severe or strong penalties and then you increase them even further. We don't think that there's good evidence in terms of criminology, sort of academic evidence that this will be a major deterrent. So we certainly don't oppose increased penalties, and we think that it certainly has, again, a symbolic effect in showing how significant this issue is to the government and that this is something not to be tolerated. We think it had some sort of value in that, but do we think it'll be more likely to deter someone who may already engage in hate speech or hate crime? We're not very convinced that that's going to be a major factor.
Perhaps I might ask also, and I don't know if you'll get to cover this in your submission, but whether Equality Australia has a view around the aggravated grooming offence?
Yes, certainly. We do support that one. We can see that, and the fact that it is actually broadened out to include our communities is very welcomed. Speaking to community members today, one of the things that definitely came to mind was the attacks that are happening through Grindr, so dating apps, where some will impersonate another gay person, basically get them to come to meet them at a place, rob them, bash them. Terrible things have occurred, very violent crimes. Now, most of the people who've actually committed those crimes are children. Sadly, young people who have been radicalised online to hate LGBTIQ plus people. So we do think that this sort of sense of older, responsible people targeting young people to spread their messages of hate, I think it can have some benefits for our community. So we do support it.
Thank you. Are there any other areas? I know there may be other people wanting questions, so I just want to check in if there are any other specific areas of the bill that you might wish to bring to our attention now. Appreciating you'll have a more detailed submission, but I'm just curious to try and get down on the record what those areas of concern or the bits that you are supporting equally is also interesting to us.
Sure.
And anything you'd like to add for the record today would be really helpful. Thanks.
Probably the biggest annoyance or the biggest sting for me was seeing that we're not included in the aggravated sentencing factors. For us, we didn't see this as a particularly controversial provision. These are people who've gone through a full criminal process, have already been convicted of an underlying offence, and then this is simply, can you consider in the sentencing factors the fact that there was a hate motivation or demonstration? It is exactly the kind of formulation that we strongly support, and we note that it actually mirrors the drafting of legislation that was passed through bipartisan support at the end of last year. We just couldn't see why you would have why we would have been cut out of this, because we don't see it particularly controversial, but we also see it as having potential great benefits for our community. So that one we feel is quite really could be quite easy to address.
Can I just end perhaps to hand across to others who might have some questions, but do you, I guess in the broader sense, I understand your misgivings of this bill and you're feeling excluded in important aspects, but can I ask you, does Equality Australia have a view about, is there a support for the intent of the bill, notwithstanding some of the provisions that you've just mapped out for us? Is the intent of the bill something that Equality Australia is supporting? That's my first broad question.
Yes.
Yep. Thank you. And I guess, is there any acceptance that there is a need to strengthen those hate speech laws? And if so, then what would be your advice to this committee on doing so?
Well, this bill should pass. I think that's the bottom line. We think that certainly in the aftermath of the Bondi attack, it's very clear that people need better protections from racist attacks. And that there are benefits not only for Jewish communities, but of course our First Nations people who often experience these ongoing hate speech online and in person, also the anti-immigration or anti-immigrant sentiment that we're seeing as well. So we do support this bill. But the bottom line is we shouldn't be left out of this. There hasn't been a good justification given to me at this point. We've been previously told to wait our turn, and that's happened in New South Wales, where there was changes made to strengthen only provisions in relation to race. In fact, then they're mirrored into this Commonwealth bill. We've spent a good part of a year then advocating to make changes to bring us back into those laws, including putting huge resources in to a review that hasn't even sort of seen the light of day at this point. So it does get really frustrating to be told to wait. I think we've been sounding the alarm, just as Jewish communities sounded the alarm for a long time about the escalation of hate. We'd like that to be taken seriously.
Thank you so much. I'm very conscious that I didn't give you an opportunity. I'm just looking to get your name right, Mr. Alpaka. I didn't give you an opportunity to make any comment. Is there anything further that you would like to say to the committee?
Just want to add with the aggravated sentencing that this is something that has already been addressed in other jurisdictions in Australia. So Tasmania recently did it in December. Queensland, New South Wales and South Australia have already done that as well.
Okay, well, thank you both very much and for your considered opinions, and we look forward to receiving your submission and working through these issues together. Thank you, Chair. Back to you.
Okay, thank you. Now, Senator Dunham, I think you had
thank
question.
You, Chair. Just one question. Ms Corkill, you mentioned at the beginning you weren't consulted and you've provided a range of views, and I think you said that you will be providing a written statement, and given the short time frame, I appreciate you doing that. Have you had any contact with government since about any of the concerns you've raised, or made direct contact with the Attorney General's Department or the Attorney General's Office to seek expanding the laws in the way you've put to the committee this afternoon? Yes,
certainly. We had a departmental briefing which was just set for yesterday evening where we were able to talk through the bill, raise some of the concerns now, but of course we were encouraged to put that into writing and then appear today. That's as far as we've been able to go at this point.
Okay, so you've through this process is how you are communicating those desired changes. Is that the point, rather than directly to government? Yes.
Yes, that's right.
Okay,
yeah.
all right. Yeah. No, thank you very much for that. Thank you, Chair.
Okay, thank you. And thank you again for your attendance today on short notice. And if we've asked for any information on notice, if you could please provide whatever's required by the end of today, that'd be great. Thank you so much. We'll now move to our next witness on the program, as I understand it, Cattle Australia and the National Farmers Federation. Oh, okay, we'll just get the name tag sorted out there, but welcome.
I'm Chris. Yeah, Chris Graves.
Try and work out which Chris. Is it?
Thank you.
All right, I now welcome representatives of Cattle Australia and the National Farmers Federation to give evidence at this public hearing today. Now, for the Hansard record, could I ask you to please state your full names, apart from Christopher, and in the capacity in which you gentlemen appeared before the committee today?
Yeah,
Start with you, Chris.
Yeah, Chris Groves. I am chairman of the Farming Systems Committee at the National Farmers Federation, as well as a farmer from between Cowra and Canowindra in the central western New South Wales.
Thank you. Dr. Chris?
And Dr. Chris Parker, Senior Advisor with Cattle Australia. I'm also a primary producer at Murray Bateman.
Although the committee does not require you to give evidence under oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, did either of you gentlemen have an opening statement or remarks this afternoon?
Look, good afternoon and thank you for the opportunity to appear today. The NFF acknowledges the terrible events at Bondi Beach in December, and we believe there is no place for such violence and that type of hatred in Australia. This bill covers a wide range of issues, from anti-Semitism to extremism to firearms. The NFF's role is to ensure that farmers have the tools they need to do our jobs properly. That's why today we can speak about the parts of the bill that relate to firearms and how firearms are a critical tool that we use to uphold our on-farm biosecurity, and they're also a critical tool in animal welfare. The NFF supports sensible reforms that strengthen community safety. We recognise the intent of this bill is not to restrict the lawful and safe use of firearms in agriculture. However, it is vital to ensure that law-abiding farmers who rely on firearms as an essential tool for food and fibre production do not face any unintended consequences from rushing the process. Thank you.
And Dr. Chris Parker, do you have anything?
Thank you, Chair. Just very briefly, look, we also acknowledge the terrible events at Bondi in December, and we need to ensure that action taken to avoid these sorts of things in the future is appropriate and doesn't have unintended consequences. Firearms play a legitimate and essential role in Australian agriculture. They are critical for best practice animal welfare, and they're also critical for controlling invasive pest animals and pests that threaten biosecurity, something that would cost the nation an enormous amount of money, as I know you're aware, Chair. Also important to securing food security and also protecting our ecosystems. Their use is already highly regulated, and farmers take their responsibilities under these regulations extremely seriously. We should not have any unintended consequences, and we would like the committee to have this as front of mind in your deliberations over this exposure draft. And these unintended consequences are exacerbated by both the speed and also the size of this omnibus bill. Thank you.
All right. Now, I'm going to hand over to the Deputy Chair to kick off with questions. Over to you.
Thank you, Chair, and I'll be brief and then hand my time to Senator McDonald. Thank you both for joining us today and acknowledging the tragedy that happened in Bondi. My view with this is the terrorist attack that happened at Bondi is not a gun issue, and we're here because of radical Islamic ideology. And the people that I represent in Townsville, in farming areas, feel adversely punished, and we've heard commentary about getting rid of belt-fed shotguns, which don't exist. So my question to you both is, as farmers, as someone that are, people from the land, how are you, or the people you represent, what do you think about the changes to the gun legislations, or any sort of insight from your people how this could adversely affect you?
I guess one of the main things as farmers, we need to be able to access a wide range of tools to do our job. And something that we are a little bit concerned about is rushing through legislation that may have unintended consequences. We have a process that we need to go through to have policy, but most of NFF's policies and NFF's Charter for Operation is just ensuring that food and fibre production in Australia can continue and be done without unnecessary impediments. Now, the tools we need, we have shovels, we have chainsaws, we need firearms. It just fits in the category of something we need to have access to conduct our businesses.
Yeah, we've heard, I can only assume people from the city want to tell us about what's happening in the bush. I just wanted to, before I hand over to the next committee member, I just want to say thank you for what you guys do. From the paddock to the plate, it means a lot, and I really appreciate your input on this very significant issue today.
Thank you. We'll take that.
Thank you, Chair.
We'll take that back.
Okay. Now, Senator McDonald.
Thank you, Chair. Mr. Chris,
yes.
Not Dr. Chris.
Yes.
I've just escaped your surname. I'm sorry.
No, that's all right. Chris Groves.
Thank you.
That's all right.
Mr. Groves. I wanted to talk to you. I've had a number of farmers and graziers contact me about the different sorts of firearms that they utilise for different measures on their properties. I've been concerned that some of the rhetoric has become very people who don't like guns versus people who either utilise them for work or recreation and choose to own guns or be licensed for guns. So I thought we should start by just asking you to speak to the different styles of firearms that farmers and graziers might need, whether it be vertebrate pest control or whatever. Anyway, if you'd speak to that, please.
Yeah, certainly. It's interesting in the way we farm in Australia, there is a wide range of firearms needed, different types, different categories. It certainly, as you said, it depends upon what pest animal you're dealing with. Sometimes there needs to be the ability to reload fairly quickly if you're in the scenario of pig hunting, for example. But then in the other case, there's what we've seen in Victoria over the last few weeks, the last few days actually, is the horrendous bushfires that have gone through, and access to firearms and access to ammunition, small bore rifling, things like that. They've been critical in ensuring that the clean-up after those fires has been as expedient as possible, because an animal suffering with burns is something that nobody wants to see and wants to have to live for any longer than they need to. So there is a wide range of firearms, and they do all serve a purpose in various scenarios.
Some people have contacted me with concerns that the use of ammunition reloading equipment would become illegal, is proposed to be restricted under importation. Are you aware of any concerns raised about that?
Senator, at the moment we're not across a lot of the detail. As everyone has said, this has been a fairly quick process. Even the fact of us being here today was only come along from yesterday. So we're unsure at the moment of the ramifications for firearms. We do reload on our own farm at home as well, but that is a money-saving venture as well, but it's also an accuracy factor. Once you start talking grams of powder and weight of projectiles and all that, we can load a particular shell to suit the rifle that we have. It is a science. It's not just a whack a bit of powder in and put a pellet in the end and hope for the best. So really, any limitations on that would be problematic in certain scenarios. But as I said, we're unaware of the detail at the moment, and we need to look at the various legislations, the various state legislations as well, to see what the ramifications will be of what is being proposed or passed already.
So can I assume then, well, the department tells me that they didn't consult with farming groups in the preparation of this legislation. Were you consulted? Did anybody reach out to you in any forum or format to consult on this?
Senator, certainly Cattle Australia wasn't consulted in regard to this, and we represent about 56,000 levy payers around the country, the vast majority of whom would own firearms for use as a tool on their property. I do note, and I understand the NFF after the fact have been offered a briefing, but I understand that's at this time when we're appearing. So this is rushed. This is a challenging environment for organisations like ours to be able to get out and consult with members appropriately. That is notwithstanding the absolute tragedy of the events that occurred, and it in no way detracts, and our comments today about ensuring no unintended consequences for producers who need a particular tool because of an appalling event that happened in Bondi need to be taken in that context, Senator. So we are in no way opposed to action being taken by the government across a range of areas to deal with what is clearly an issue for Australia at the moment. Our view and what we're talking about is simply one component of that, which is the firearms component. And what we would like to see is the government and this committee to keep in mind unintended consequences, and your reloading question is a good example where that may well be the case. And I'm sure that was not an intended consequence of this gun legislation. So, and if it is, well, then we would have something quite strong to say about that, given the need for a range of people to be able to reload their own ammunition to ensure that they have cost-effective tools available to them. Thank you.
Thank you, Dr. Parker. Look, one of the elements that also concerns me is I've just spent time in the floods of North Queensland, and we've also just talked about the the fires in southern Australia, both locations where the use of different kinds of firearms has been a very necessary part of managing animal welfare in those places. I'm also concerned, though, about mental health for farmers, graziers, recreational shooters. I'm told, I'm getting a wave of people contacting me saying that they feel that they are being disenfranchised, that their livelihood and their preferences are under attack. And indeed, we just had evidence earlier this afternoon from somebody who said that 6% of the population shouldn't determine what the rest of the population's views were on firearms. I guess this is my biggest concern, is that farmers and graziers and so forth will consistently be told and patted on the head, don't worry, this won't change anything you do. But of course, it's the straw that breaks a camel's back of feeling under attack and misunderstood. Anyway, that was a very long statement. I guess I would like to ask you, would you speak to what your views are from the farming organisations, the cattle organisations on exactly this matter?
Farmers, unfortunately, we have had to get used to being under attack because we're under attack from various various aspects all around the time. We've got, sometimes it's legislative, sometimes it's ill-informed groups that don't like what we do. And I guess what you're saying about feeling under attack once again is something that we want to represent our members. And the NFF's members are the organisations around Australia that have the farmers as their members. So we are basically the next level up from representing the farmers, but we get information from every farmer organisation around the country. And yes, there will be this feeling that why should we have to give anything because we didn't do anything wrong, none of our people did anything wrong. That is a feeling that may become common around regional and rural Australia. But I guess we also need to be responsible citizens and realise that something does need to happen because of the tragic scenario we saw in Bondi. We are representing our members, trying to make sure that it doesn't affect our ability to do business, and we also have to monitor that and point out to people that yes, something has to happen, but we are not the ones that should have to give up our equipment that we need to conduct our businesses just because of what happened. It's a double-edged sword. We need to be aware of what happened and probably make the appropriate adjustments that are needed, but we also certainly need to be aware that we're not limiting agriculture to produce feed and fibre.
So,
Chris, have you...
Senator, if I could maybe just add there is a feeling, I think, that the series of reforms following Port Arthur have not even been completed. We don't have a national firearms register. One of probably, in my view, one of the more important reforms from those that were put in place. So I think there's a feeling, well, here we go again with a whole lot of reforms and a whole lot of changes when we haven't even completed, the governments haven't even implemented the last lot of changes. So again, I think there is a level of angst, I wouldn't say anger or anything like that out there. Like Chris said, people recognise the responsibilities to manage their own firearms, the legal firearms, which is a tool they need, in an appropriate fashion. But we'd also like to see where reforms are put in place that they're completed, and they're completed before more reforms are put in place. And on top of that, we'd also like to see that there is evidence that the current laws are being enforced appropriately, because it appears to me, as a concerned observer, that there may have been some challenges with the manner in which legislation and those gun laws have been both administered and enforced. So if we can be part of improving things, we welcome that opportunity. It's pretty hard to have that opportunity when you're told yesterday to appear here and we don't even have a necessary briefing that sits around what is a very complex piece of legislation that involves not just firearms, I'm sure, as you know, and you've been hearing today and yesterday about the whole range of other issues covered in this omnibus bill.
I think your point's well made about making sure that existing legislation is properly utilised before we go introducing more legislation. And I think that's something that will certainly come out during the Royal Commission, and we will wait to see the results of that. Some of the recommendations or suggestions that have been coming through in addition to this framework of firearm buyback is around gun storage, the National Register, which, as you've already raised, was something recommended some time ago, which hadn't been actioned by government. But are there elements that you are hearing that you think are useful? Because whilst everybody is absolutely in shock and horror about what's happened, I don't think that to date, farmers and graziers, that there has been changes to legislation identified that would have prevented the tragedy, or that would have been necessary given the existing legislation that's in place. So I guess what I'm looking for from you is, do you have recommendations that you would like to see progressed?
At this early stage, we haven't even been able to bring our members together. There's been a few phone calls around the country to get a basic agreement on where we are. As I said earlier, our policy is all about making sure that farmers can conduct their business. But where this is leading to, I think we need a lot more time to look into the detail, work out the exact ramifications of what is being passed, and also bear in mind that all our members have state legislation that they have to look at, and they have to look at the ramifications of that as well. So it's a hell of a job. It is a big job to get around and make sure all this legislation is covered and we see every detail in the depth of the legislation. As well, legislation is great. It's the implementation. How's that going to happen as well? That we have to consider, we have to look at, and it's going to take a lot of time. It's one of those things that we need to consult. We need to have committees get together and form policies where we can then go forward and pursue those policies to make sure that nothing that comes out of this legislation will impede our ability to continue as we are. Chris?
I don't have any specific recommendations for this committee. Again, that's a function not of my lack of desire, but simply the speed of which this is and the ability to be able to get the level of detail that's going to be required for appropriate consultation with members of Cattle Australia and levy payers. Look, it is just worth remembering that current laws are already some, if not the most restrictive in the world. There is a significant cost burden and a regulatory burden associated with those laws, and we need to ensure that any modification or change to those laws doesn't add further to that regulatory and cost burden. These are, as we've both said, almost ad nauseum, I apologise, these are important tools and they are vital tools. And I have personally had to put down sick livestock. I've personally shot vermin. These are not pleasant tasks, but they are essential tasks. And they are essential tasks that primary producers do on behalf of the nation in producing the food, fibre and grain that we do. And I recognise, Senator, that there are lots of people in this country who don't like guns, who have no experience of guns. And maybe that's a success from the Port Arthur reforms. And maybe that's in fact, I would say that's a good thing that we've seen such small amounts of gun crime in this country since those reforms. But that doesn't take away from the fact that there are parts of our production system that require these tools, and there are already laws in place that law-abiding Australian producers abide by every single day, as do I. They're under lock and key, separated in two different places, in two different gun safes at my property. And we all do those sorts of things. Thank you.
I guess one thing that I am conscious of is that while as farmers and graziers there is a separation between talking about recreational gun ownership, sporting, target shooting, social aspects, all of those other things, and that we have to be careful that if we separate gun ownership into people who can use them for a job and then everybody else is abandoned, that seems to me to be an unhappy landing place because, you know, so many farmers and graziers have the ability to also enjoy recreational shooting, hunting, target practice, all of those things because they have access to land to do that on. How do you support those kind of people who live in cities, who have either cultural, an interest in recreational hunting, who during COVID discovered the shortages of fresh meat and they wanted to still enjoy hunting? You know, there's a long number of reasons why people might enjoy owning a firearm, and yet it seems to me that if we're not careful, we're going to separate people into need it for work and everybody else doesn't get one. Could you speak to that?
It is something that government will need to be very careful of. We, as a farming community, a lot of our younger people do have an interest in hunting and it is an off-farm thing. It's not so much a side issue, but something I learnt today. There's a long-range target team being sent overseas to represent Australia, and I think it was 78% of the competitors are farmers or employed in the agricultural industry. I guess it is a recreation for a lot of young people in the rural and regional areas. I'm unable to speak, and I'm not sure how you get around the one of people in the city who still have an interest in it. That's probably another. There are organisations, the Sporting Shooters Associations, the retailers also have an organisation, the Firearms Retailers, the SIFA. I'm not sure what that acronym stands for, but they have their own organisation, which is also actively trying to engage at the moment with all their members. So we speak on behalf of the farmers and the farming community, and as I said, our members are the various organisations around the country, and we are concerned from their point of view. But you have definitely raised a very valid point that a lot of these people who just have an interest in red meat procurement, things like that, there's a whole section of society there that probably will need to be looked at, that we're not alienating them or painting them as some sort of evil force.
That's right. I mean, we have a parliamentarian who is a Commonwealth Games participant in shooting, target shooting, and I think that is an exceptional skill, one that I don't share, unfortunately. I will just finish on a couple of other questions because I know the Chair is short of time, but I want to just ask you, have you turned your mind to the buyback scheme and compensation, fair compensation, not only for firearms but also for all of those ancillary items that I know a number of people would have, optics, ammunition, reloading equipment. We've touched on projectiles, magazines, spare parts, mounts, etc.
I guess if our community, our farming community, is being asked to give up something that they've had to pay for, yes, there definitely needs to be compensation. But the thing is, once again, we're not sure of the final details. We don't know how the buyback scheme will work. And I guess we are just asking that we can keep consulting with the lawmakers, the legislators or the instigators of that legislation. If we can keep consulting so that if this process has to happen, we can make it as smooth a transition to this new world that we're aiming for as possible.
We know that a number of firearm dealers have had difficult times. A number of the banks have tried to debank them. I'm really concerned that their businesses are under threat because of the, people now not being confident about buying goods from them. And of course, most of these are based in regional places. So no doubt you will be keeping an eye out for them and representing their views as best you can if required.
Senator, we do. I spoke to our local firearms dealer this afternoon in Cowra, and they are really considering their future because he said sales have dropped since December. He said we have just seen a complete drop-off in sales, and they are questioning their future. And I would say, as would every retailer of hunting equipment in any regional town, because it's really it's a world of uncertainty for them at the moment.
Senator, we need to...
It's death by 1,000 cuts.
Well,
yes, Dr. Parker.
And we just need to ensure the actions of a deranged few are not in any way set to change the ability of law-abiding citizens to use the tools they need for both their recreation and their work. We wouldn't want to see a distinction between those two functions. They are law-abiding citizens, abiding by the laws of the land, abiding by the gun laws. I see no reason why they shouldn't be able to purchase a firearm after going through the appropriate checks and the appropriate licensing to enjoy what is still a legal activity in this country. And I do note, as you've pointed out, is still used in competition in both the Winter and the Summer Olympics and the Commonwealth Games. So these are important parts of this country's culture and heritage and also people's enjoyment of life.
All right. Well, look, thank you so much to both to you, Mr Groves, and to you, Dr Parker, for coming to provide evidence at probably less than 24 hours notice on legislation that you've not had an opportunity to digest and certainly weren't consulted on. Thank you for your engagement this afternoon. I'll hand back to the Chair.
Thank you, Senator.
All right, thanks a lot. No other questions from other members? No? All right, thank you very much, gentlemen, for your time today.
And thank you for the opportunity, Chair.
Thanks for the opportunity.
And if there's any information that we've requested, I'm sure you'll provide something to us by the end of today.
Thank you.
Thank you. All right, now we're now going to move along with the program. I'm just mindful that we're just slightly behind schedule, but I'd like to now welcome representatives of the Australian National Imams Council to give evidence at this public hearing today. Good afternoon.
Good afternoon.
For the Hansard record, could I ask that you please state your full name and the capacity in which you appear before today's public hearing?
My name is Imam Shadi As-Sulaiman. I'm the President of the Australian National Imams Council.
Thank you very much, Imam. Could I just mention here that although the committee does not require you to give evidence under oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Did you happen to have any opening remarks or statements that you'd like to provide the committee this afternoon?
Yes, I do.
Please proceed. Thank you.
Thank you. We thank the Parliamentary Joint Committee on Intelligence and Security for the opportunity to engage with its review of the exposure draft legislation combating anti-Semitism, hate and extremism Bill 2026. The Australian National Imams Council is the peak representative body of Muslim religious leaders in Australia, representing more than 350 imams across all states and territories. ANIC works to preserve the Australian Muslim identity while strengthening a shared sense of belonging among Australian Muslims, grounded in both their faith, Islam, and their commitment to Australia as their home and country. ANIC and the Australian Muslim community unequivocally condemn the recent terror attacks in Bondi. Such acts of violence are rejected by Islam, Muslims, and all faith communities and stand in direct contradiction to religion and its teachings. We extend our deepest sympathies to the victims, their families and loved ones, and we stand in solidarity with the Australian Jewish community at this painful time. The perpetrators who took the lives of innocent people on the 14th of December 2025, while targeting Jewish people, were motivated by a violent terrorist organisation that has inflicted immense harm on many communities, including Muslims worldwide. ANIC, the Australian National Imams Council, has consistently and publicly condemned ISIS since its emergence and continue to do so, as stated publicly on the 16th of December 2025, and on many occasions prior, that ISIS is an evil, dangerous terrorist organisation with no connection to Islam. The Muslim community feels it's being subjected to heightened scrutiny in the aftermath of the Bondi attacks and is bearing the burden of suspicion because of the actions of terrorists and criminals. ANIC supports strong action against all forms of hate and violence against any community, race, faith, or those of no faith, while not undermining freedom of speech and expression. ANIC raises serious concerns with both the process and the substance of this bill. This legislation has been rushed through with less than a week's consultation, despite proposing major changes to criminal, national security and migration laws. There must be meaningful and good faith consultation with faith leaders, Muslim communities, and Palestinian and Arab civil society organisations, given these groups are among those most directly affected. Legislation of this magnitude requires careful scrutiny. Proceeding at speed weakens the quality of the law and undermines social cohesion. As drafted, the bill treats religious leaders as a risk factor. It introduces aggravated offences targeting religious and community leaders and relies on narrow defences that do not reflect how faith is actually taught or lived. Islamic and religious teachings involve theology, ethics, and engagements with social and political issues. Without explicit safeguards, religious sermons, pastoral guidance, and public religious commentary may be criminalised, prosecuted, or unfairly targeted. The bill also creates serious legal uncertainty by exposing past lawful speech to new penalties. This contradicts fundamental principles of the legality and places religious leaders whose sermons are often public recorded under ongoing retrospective risk. Taken together, these features disproportionately burdens the Australian Muslim community. Islamophobia is not recognised as a protected category, despite well-documented increases in Islamophobia and anti-Muslim harm and hate in Australia. ANIC's position is clear. Laws to combat hate must not suppress lawful religious teachings, must not apply retrospectively. We are calling for explicit protections for religious instructions and teachings. This includes quoting and interpretation of texts from sacred books and scriptures, the recognition of Islamophobia within vilification laws, and genuine consultation with faith communities before the legislation proceeds. This is how we can protect communities from hate while strengthening democratic freedoms and not undermining social cohesion that holds our nation together. Thank you.
Thank you very much. I appreciate that. Now, I will turn to, I think, Ms Clayton. Did you have some questions? And then I'll go to Senator Duniam.
Thank you very much, Chair, and thank you to the Imam. I appreciate you are here with short notice, and we are all operating within these tight constraints of time. Just before, you've pointed to a couple of concerns, and I do want to come to those in a moment. I just wanted to ask a broader principal question at the beginning, which was whether or not ANIC has a view whether there is a need for the Commonwealth to strengthen hate speech laws.
At this moment, we are more concerned about the vilification laws with regards of Islamophobia not being included. Okay. We understand that race is protected, but attributes to faith is not, and Islamophobia has been on the rise. Just 2 days ago, we had a prominent imam who was bashed, him and his wife, just because they were Muslims, and this is becoming an ongoing thing every single day. So right now, we would like to see that Islamophobia and the protection of faith to be included in this bill. As for hate, our position is very clear. We reject any form of hate and violence towards any community, regardless of people of faith or no faith, colour or race. However, this needs further consultation because we understand that what's been perceived to one community as hate is freedom of speech to another. So that's why we start with the first concern. Such a bill is rushed and it needs to be scrutinised and given more time for consultation and to get this right.
Thank you. Can I ask, I note you mentioned earlier some concerns around the aggravated sentencing for religious leaders. So I'll go to that one now, if you don't mind. And appreciating the point you're making, I just wanted to kind of clarify or just to tease that out a bit further really was because that aggravated factor would only apply at sentencing once a court has convicted a person for an existing offence. So do you think there are any circumstances, I guess, in which leaders in positions of influence in communities have any kind of greater responsibility which should be reflected in the sentencing, or is that would you accept at any level, I guess? Is there a kind of a higher requirement perhaps of people in leadership positions?
Religious leaders, political leaders are all responsible in maintaining social cohesion and bringing the community together. That's a core responsibility, and that's a commitment from the Australian National Imams Council and the vast majority of Australian Muslims in this country. Now, as for what's being proposed in the bill, we've just received the draft yesterday and we need further time to look into it, and we are aiming to make a submission tomorrow, given further details after our legal team looks into it.
Oh, excellent. Thank you for that. And again, you know, we all do appreciate we're all pushing against time here, and that being able to get a submission to us tomorrow would be great news. So thank you. I'm just wondering also if ANIC has a view on the inclusion of the religious text exemption. That's a specific subsection within the bill, the proposed bill, and whether you consider it appropriate or necessary to have an exemption that allows for quoting directly from or otherwise referencing a religious text for the purposes of religious teaching or discussion. Do you think it's broad enough, or conversely, is it too broad?
We do believe that faith leaders and faith communities have the complete right for them to quote any verse or any text from the scripture and interpret that to their understanding. This is a very important fundamental right that we believe not only as Muslims but other faith communities, and we share our concerns with other faith communities with regards of the restrictions of religious leaders quoting certain texts from the scripture, which can be perceived by others or some communities as a form of hate. Again, this is another topic that we are addressing in our submission, but on the face of this and in principle, we do believe that faith leaders must be given their freedom of right to express, quote, and also explain their religious scripture.
Thank you. Might I just also ask if you've got any concerns around the new listing regime for prohibited hate groups?
That's a concern that we do have. We understand that there's already a category of terrorist organizations, but now there's another category that the bill proposes to have a hate group. We don't understand what it implies to be a hate group and who would be included in that. So that's another concern that we do have. The implication of it, the policing of it, and how do you measure it?
And is there any thoughts you've got at this early stage around the bill's imposition of some higher penalties for hate speech?
Not at this moment, but it will be through our submission,
okay,
which we are working on. Given only 48 hours to try and get something in, so we've got all the legal team working on it day and night, and that's another concern that I'm sure you've heard from many of the witnesses, which has been raised, rushing this bill and not giving ample or reasonable time for communities to look into it.
Okay, I do thank you for appearing today again, and I just wanted to give you an opportunity in case there was anything we missed at this early stage and you're thinking about any other parts of the bill that you might want to, we haven't had an opportunity to discuss now, if there's anything else you really wanted this committee to be alive to before your submission arrives tomorrow or the next day.
I've made that very clear in my opening comments, and it's very unfortunate to say that faith communities, in particular the Muslim community, feels targeted by this bill and raises serious concerns over it.
Well, again, I really thank you for taking this time to at least bring some of those concerns forward for this committee's consideration. We do appreciate it, and we'll look out certainly for your submission as well. Thank you very much.
All right, thanks a lot, Ms Clayton, and thanks, Imam. Now, Senator Duniam.
Thank you, Chair. Thank you, Imam Al-Suleiman. I appreciate your time with us today. We saw some reporting earlier on today that the Australian Federation of Islamic Councils have called on the government to delay passage of this legislation. Can I ask you've sort of gone there in your opening statement and some of the answers to Ms Clayton's questions, but is that the position of the National Imams Council as well, that the passage of this legislation should be delayed until proper scrutiny is allowed to happen?
Definitely, that's our position. We believe that this is rushed, and rushing such an important bill like this will undermine many aspects of the Australian people, whether it's the freedom of expression, religious freedom, and other aspects. So definitely we do agree, not only with the Australian Federation of Islamic Council, but many other faith communities and Australians who see that this bill is so rushed and we need more time to scrutinise it, understand it, and make proper submissions.
Thank you. To the issue of consultation, there has been a lot of criticism of the time or the speed with which this process is occurring, but also with the consultation or not that has occurred. I was asking officials from the Department of the Attorney General's Department yesterday about consultation with non-government entities. They've listed the Australian National Imams Council as one of the groups that was consulted. They say on the 11th of January 2026. Was that a meeting or a discussion that you were a part of?
Yes, I was, and the Australian National Imams Council was invited to a rushed consultation with a draft bill. And I believe at that time, from my understanding, that the entire bill was not completed, or the draft bill was not completed. So we were asked a few questions, and the very same thing that I've mentioned right now, I did mention in that consultation, and we've sent an email suggesting that ANIC does not support the current bill as it stands, and we have serious concerns on the way that this process is taken and the speed of this process.
And did you say that at that meeting there was draft provisions of the bill or whatever existed of the bill available at that point in time?
They mentioned a few aspects of the bill, so obviously they didn't give me, I didn't have a copy of the entire bill.
Sure.
They spoke a few aspects of the bill, but at that time, from my understanding, it wasn't completed, or they are going through the process of completing it.
Okay. Did you ask, or did anyone else who was at that meeting from ANIC request a copy of any provisions of the bill?
Yeah, we did, and they did mention in the meeting they'll be sharing it with us, in which we did receive it yesterday, and we received some parts of it on the day.
On that day, on the 11th of January?
On the day, yeah, some parts, just a summarised version of it.
Okay, you received a summary of elements of the bill on the 11th in writing?
Yes.
Okay. Yes, they indicated they didn't provide anything on the 11th of January, so that's all right. We can interrogate that with them, but clearly different documents, summary versus actual provisions. It
was a very summarised document, so very summarised document, just a brief. Let me call it a brief, and it was referred to us as a brief.
Sure, okay, got you. That makes sense. Thank you for that. I wanted to go to some other reporting today. Another government minister, Dr. Anne Ali, mentioned that the government was open to expanding the scope of this legislation to include potentially Islamophobia. Is that a concept that has been raised with you by government?
Not at this moment with regards of the consultation, but this is something that we've raised in the past, that we would like Islamophobia to be added, and the vilification against vilification against religion to be included as part of the bill. Okay. That's been part of the ask of ANIC for many years. So before the 14th of December, and even now throughout this process, we've been asking that we would like to see Islamophobia added to it.
Sure. And has Dr. Ali been in touch with with ANIC?
Dr. Ali, she's the Minister for Multiculturalism, and she's in regular contact with ANIC and members of the Muslim community, but not recently, throughout this week.
Okay. And just back to that meeting of the 11th of January, I presume a range of concerns were put on the table by the Imams Council in relation to what you were briefed on, what was contained in that brief, as you put it before. You put on record those concerns at that time?
We did mention to them on record that we don't agree with the bill and we are concerned over the speed of this bill.
Did they raise with you the concept of the religious text exemption that we've talked about already today? Did they...
That was mentioned as a defence.
Yeah, okay. From ANIC's point of view, what would be the function, because we've had a lot of people criticise the defence, other witnesses throughout the course of this afternoon. From ANIC's point of view, the functioning of the bill, what would that be like from your organisation's point of view if no defence existed in what was passed through the Parliament?
So if the defence was removed, how would that bill look like?
Yeah, well, well, how would its application impact ANIC and its members and the Muslim community more broadly?
Well, I'm just going to speak from the minimum knowledge of understanding that bill within the last few hours.
Understood.
Or the last few days. Obviously, it will impact the religious communities and the Muslim community in particular with regards of quoting texts from the Quran or from the prophetic traditions, and that can be interpreted in different ways. That this is promoting maybe hate or prejudice towards other communities, which is not the intent. And that's not the interpretation in any way, in any form, in any shape. Likewise, as it is with other faith communities who share the very same concerns as the Muslim community. So we are concerned that religious freedoms and quoting texts from the scripture are not protected.
Okay. Do you have any sort of rough time frame you think would be acceptable for proper considered scrutiny of this legislation from ANIC's point of view? Obviously, our timeline, as outlined by the Prime Minister, is to have these bills passed within the week. What would be an acceptable time frame for you?
I believe something like this needs weeks. From our previous experience, something this magnitude will need at least 4 to 6 weeks just understanding the bill, consultation, making submissions. And I'm not the expert in this area. I'm a religious leader, but 1 week is unreasonable.
No, understood. Thank you very much for your evidence.
Okay, any other comments or any members? No? All right, well, thank you very much for your attendance today. I'd really appreciate it, particularly on short notice. If you've been asked to provide any further information to the Secretariat, if you could do so by the end of today. We'll now move on with our program and to our last block of witnesses who are online. Could I now welcome representatives of the Australian Catholic Bishops' Conference, the National Council of Churches, and Bishop Michael Steed to give evidence at this public hearing today. And now for the Hansard record, could I ask all of you please to state your full names and the capacity in which you appear today, and we'll start with the Australian Catholic Bishops' Conference, if they're online. No, we've got Michael Steed. Bishop Steed, are you there? I can see you down there.
I am.
Yep.
Yep. My name is Michael Steed. I'm the Anglican Bishop of South Sydney, and I'm also the Chair of Freedom for Faith.
Excellent. Anyone else there from the National Council of Churches? If not, we've got Mr. Redmond. Okay. Mr. Redmond, are you there?
I am. G'day. How are you going?
Yes, thanks. We've just started, so if you wouldn't mind, please just state in your full name and the capacity in which you appear today, please.
William Redmond. I am the Assistant Director of Public Policy at the Archdiocese of Brisbane, but I'm representing the Australian Bishops' Council.
Excellent.
Australian Catholic Bishops' Council, sorry.
Yeah, thank you, just to be clear. And I think Ms Stone is not with us, but I'm sure she will join us at some stage. But as I was saying, although the committee doesn't require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standings as proceedings of respective houses. Giving a false or misleading evidence is of evidence is a serious matter and may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Now, I think Ms Stone has now just joined us too. Hello. For the Hansard record, could I ask you to please state your full name and capacity in which you appear, please? You're on mute.
Elizabeth Stone, General Secretary of the National Council of Churches in Australia.
Thank you. Now, given the short time frame, we're working to complete our review. Could I ask you please to answer all the questions or provide as much information to the best of your ability in the evidence today? Now, Bishop, did you have an opening statement or remarks?
Yes, I'm happy to make an opening.
And then
I'll have an opening statement.
Thank you. And I'll ask the others if they have something to say. Okay, the call is yours.
I thank the committee for the opportunity to appear, but I'd like to register at my outset my grave concerns about the rapidity of this process. The bill, 144 pages, the explanatory memorandum, 319, were only received yesterday morning, and it is unreasonable to expect any adequate analysis of the bill in the space of a bit over a day, let alone written submissions by 4 p.m. tomorrow. I'm going to be arguing that the committee ought to recommend to the government that the bill needs further scrutiny and therefore that it can't be voted on next week.
Can we just find out? Sorry, Bishop. Thank you.
Thank you. The bill raises very serious concerns. To list just three, there are multiple and competing definitions of what constitutes hate, a hate crime and hate motivation. There is retrospective hate crime in relation to prohibited hate groups, and there's overly broad ministerial powers in relation to those groups, overriding the normal requirements for procedural fairness. But the thing that really concerns me most about the bill is the new offence of publicly promoting or inciting racial hatred in Section 82BF. Section 82BF seeks to criminalise speech that is neither violent nor extreme. It sets the bar way too low for any offence that could result in 5 years imprisonment with a high degree of uncertainty. Whether an act is criminal or not depends on the inferred response of a reasonable member of a target group. So if my conduct would make a reasonable member of a target group apprehensive of facing harassment, then I am within the scope of 82BF. I just think that is extraordinary that we would consider a 5-year criminal prohibition on that. This is an unwarranted limitation of freedom of thought, conscience and belief, and also of freedom of expression. And those issues are simply not adequately covered in the explanatory memorandum. What it says about those sections actually is a joke, except that it's not funny. It's worth noting that a similar proposal for a serious vilification offence has already been considered by the federal government, and it was rejected for that very reason, and it was rejected by almost all of the faith groups who were consulted. The original draft of the Criminal Code Amendment Hate Bills 2024 did have a section that proposed serious vilification, inciting or promoting serious vilification. And in June 2024, a diverse group of faith leaders wrote to the Attorney-General expressing our grave concerns about that, and it was pulled for that reason. Now, in the space of 2 days, the same, in fact, if anything, a much worse version of this provision is being put up without any significant discussion or clarification. I also note that Ms Spender, the member for Wentworth, has put up amendments to introduce the same kind of serious vilification offence in February of 2025, and that was rejected by both the government and the opposition at the time. Now, less than 12 months later, without any indication that suddenly the freedom of religion concerns expressed then have been dealt with, this is now being rushed through the Parliament. I would advise the committee to urge the government to delay, to give time for proper consideration, or excise Section 82BF from the bill if it is to proceed at haste. Thank you.
Thanks a lot. Did any of the other witnesses want to have an opportunity to make an opening statement? Will? And I can,
Elizabeth, I think you're very keen. You can go first and then I'll jump in, hey?
Thanks.
Thank you very much. We welcome the intention of the bill to combat rising anti-Semitism that led to the Bondi Beach terror attack. And on behalf of the National Council of Churches in Australia, may I extend our sincere sympathy to the families of those who were killed at the Hanukkah festival on December the 14th. As many have said, it would be preferable to have been allowed more time to discuss and consider in greater detail and depth the provisions of the proposed bill. But We recognise the urgency to put in place additional measures and quickly to stem the rise of anti-Semitism and Islamophobia, prevent further violence against the Jewish community, and address the scourge of hate speech and crimes in order that all Australians feel safe and secure in their homes, schools, public spaces and places of worship. Now, the Council of Churches comprises 18 national church members from the mainstream Catholic, Orthodox and Protestant traditions, and we maintain good relations with all other faiths in Australia. We believe that all of humanity is made in the image and likeness of God, and that we are called to love one another and all others as ourselves, and are called to contribute to building a safe, welcoming and inclusive society. All acts of violence, especially those motivated by racial and religious hatred, are abhorrent before God and repulsive to Christians. So we welcome the effort in this bill to strengthen legislation to combat racial hatred and extremism. Concerning the proposed carve-out or exemption for using religious texts for religious teaching, this seems unnecessary and open to exploitation by bad actors, religious or otherwise. The focus should not be on a text as such, but on the context, the reason why a particular sacred text is being cited and the intentionality behind its use. The vast majority of the religions in Australia promote love, peace, tolerance and respectful coexistence. Sacred texts can and have been throughout human history misquoted and abused by bad actors to incite hatred. We must guard against the erosion of free speech, which is a hallmark of Australia's cherished liberal democracy. With this bill, there needs to be clearer, objective measures to determine when ordinary speech or religious teaching crosses over into hate speech. A related point is that the bill is limited to addressing the promotion of hatred or inciting hatred towards another person or group on the grounds of race, colour or national or ethnic origin. This bill builds on existing legislation protecting racial discrimination on a number of grounds or attributes, and promoting hatred on the basis of other inherent attributes such as gender, disability and age should also be included, we believe. These people are also entitled to protection under the law. We also believe it is very important to ensure Australia's First Peoples, our Aboriginal and Torres Strait Islander peoples, and also our culturally and linguistically diverse groups of people are protected by this bill, as they are daily affected by hate speech, racial vilification, racial discrimination, social and economic marginalisation. We need to name these groups carefully, not just use generic descriptors. Beyond the scope of this proposed legislation, it will be important to increase investment in civic and citizenship education, to include awareness of combating anti-Semitism and Islamophobia, to promote social cohesion, all of which many of our Christian schools, agencies and our churches do. In conclusion, we are deeply committed to racial harmony, communal and religious diversity in Australia, and will remain engaged in seeking to protect groups in Australia subject to hate crimes and extremism, as this bill intends. And I thank you for the opportunity to address the committee.
Okay, Mr. Redmond, did you have something to say, or are we on straight to questions?
I do, thank you, Chair.
Okay, go.
Chair, members of the committee, thank you for the opportunity to appear today. I want to acknowledge from the outset, the anti-Semitic terrorist attack in Bondi last December, which shocked the nation and caused deep harm to the Jewish community and to Australia as a whole. It is profoundly sad that such an act occurred in our country, and it has made this legislation necessary today. Australia is a remarkable nation, built on social cohesion, mutual respect, and the ability of people of different faiths, cultures and convictions to live together peacefully. The rise in hatred, anti-Semitism and violent extremism that we have seen in recent years is deeply troubling. It corrodes trust, fractures communities, and undermines the shared civic fabric that binds us together. In that sense, the objective of this bill is legitimate and important, and the Catholic Church strongly supports action against incitement of violence, intimidation, and racial hatred. However, our evidence today is not about intent alone. It is about whether this legislation, as drafted and as to be introduced next week, achieves its purpose without creating serious social and constitutional risks. Our focus today is there on three core questions. First, what are the unintended consequences of the framework that is being created? Criminal law is its most effective when it is narrow, precise, and predictable. This bill as presented as being highly specific, yet it relies on elastic concepts such as serious harm, including psychological harm, and subjective assessments from the perspective of a reasonable member of a target group. These formulations invite uncertainty in application and shift seeking difficult and complex policy interpretations onto the court. That is precisely how judicial activism is encouraged, not restrained. Second, has this legislation been properly tested? The bill was introduced at speed. We received it yesterday morning. While consultation was extremely limited, we are grateful that the government for the opportunity they provided us to provide feedback. But this bill has come about at short notice, which is not conducive to a thorough analysis of such serious issues that require comprehensive legal analysis. This has not occurred. Many lawyers, including our own, have not had a chance to properly examine the provisions. For legislation of this breadth and these consequences, that process is inadequate. The committee should be asking whether we are rushing potentially dangerous legislation without the scrutiny it demands. Third, we are concerned about the expandability of this framework. While this bill currently focuses on race, colour, or national or ethnic origin, public commentary already suggests pressure to extend similar concepts to other attributes. Once a broad harm-based model is established in criminal law, expansion becomes far easier. That is not a hypothetical concern. It is a foreseeable legislative trajectory. The Church's principles are clear. Every person is created in the image and likeness of God and possesses equal dignity. We condemn anti-Semitism, racism, and all forms of hatred. We also believe that the law must be restrained, carefully calibrated, and restraint to misuse over time. A God of love and a God of forgiveness calls for us to protect the vulnerable, but it also requires us to legislate wisely. Our aim today is to be constructive. We are not here to obstruct action against hatred. We are here to highlight we're here to highlight where clarity is lacking and to urge the committee to ensure that this bill is workable, proportionate, and durable before it is enacted. I thank you, and I welcome any questions from the committee.
All right, thank you. Now, I'm going to hand over to Senator Duniam to kick off with questions.
Yeah, thanks, Chair, very much. I appreciate the opening statements and, you know, with the limited time you've had to look at 140-odd pages of legislation and 350-odd pages of explanatory memorandum on what is complex legislation, and indeed former Home Affairs Secretary Mike Pizzullo said earlier today it was one of the most significant shifts in counter-terror law for some time. So it is indeed important we do get this right, and I note all of you have made that point. I do want to go to consultation, and I notice from questions on notice answers provided to the committee by the Department of the Attorney General's Department earlier today that there was a consultation on the 9th of January 2026 with the Australian Catholic Bishops' Conference. I just want to ask a couple of questions about that. In the information provided here, it says draft provisions were provided. Is that the case?
From my understanding, that is the case.
Were you at the meeting, Mr. Redmond?
No, I was not. No.
Okay. Was it one or more attendees? Was it a senior official?
From my understanding, it was one official from the ACBC who's currently on leave today, which is why you get my presence. The joys of the short truncated, the short process. So there was one official there who I think was on the phone to another official at the time and was talking through the legislation.
Okay. Well, I hope your colleague is enjoying their leave while you're here with us. So it was a telephone briefing between...
No, they were in the room.
They were in the room.
One of them was in the room.
Yes. And someone else.
And then someone else was on the phone, from what I understand.
It says here that draft provisions were provided. Do you have any detail around that?
I believe that there was draft provisions that have made slight changes. Obviously, as you are aware, no one was allowed to take anything out. So I haven't been privy to what the draft provisions were that I saw.
Sure, okay. Do you know if the religious defence, the religious text defence was part of what was consulted on at that meeting?
I'm happy to take that on notice.
I'd appreciate that. And in terms of feedback from the ACBC to government, were there suggestions or recommendations for amendment or change, or indeed a request that this process be drawn out beyond next Tuesday, Wednesday?
From my understanding, and appreciate that I've been thrown into this with only a few days' notice,
yes.
There was some suggested amendments to it, to which I believe there were, in the final bill that we've received, those changes were made on one instance. I'm happy to take on notice, but don't have it on hand what that change was.
Sure, thank you. And as best you can on notice, that would be excellent. Yep. I'll go to the National Council of Churches and the Anglican Church Diocese. So again, it says here that on the 13th of January, a consultation occurred with both groups. At this point in time, the bill had been made public, so that was yesterday.
Yes.
So
just over 24 hours ago.
Yeah. So and it shouldn't be too hard to trawl into our memories to understand what happened there. Who represented the Anglican Church at that consultation?
I did on that occasion.
Okay, all right. And the National Council of Churches, Ms Stone, who represented?
Yes, I did.
Okay, so you were both there. The bill was public, or the draft bill, I should say, so you were able to look at that document. Can you explain how the meeting went? And at that point in time, were either entities able to provide feedback to government? And if so, noting that the draft bill had been already provided to the public, has there been a commitment from government to take on board and look at amendments to deal with some of the concerns you either way? Maybe Bishop Stead or Ms Stone, you go. Yes, please.
So I did raise a number of the concerns at the meeting yesterday. The AG's department was not in a position to make any commitment to make changes to the bills. I've advised just some inconsistency of language in a subsequent email, and they thanked me for that, and they said they would look into it. There was no commitment in the meeting yesterday to amend the bill in light of feedback.
Okay. Ms Stone, sorry, I cut you off.
No, that's okay, thank you. They wanted us to give feedback, invited it, also encouraged us to put in a submission with our comments and questions and requests for clarification. And I believe that that they didn't commit to making any changes. They wanted us to submit basically what we're offering, but they did take notes, Michael, I believe too. Did you? Yeah. So that was we had a half an hour, and that was the spirit in which the briefing was conducted.
It was half an hour. Okay. at roughly this time yesterday?
3:30 p.m.
Okay, all right. So if then I could just go to, I'm not sure if all of you did, certainly you, Ms Stone, did talk about the religious text exemption, and your view is that it is not necessary. If I can, is that correct?
I must say that I need to go to our 18 national church leaders and have a consultation on this.
Sure.
But we just wanted to say that in many ways, the misuse of religious texts has happened in the entire human history.
Yes.
To be honest, and that there's a very important principle here that I don't think is reflected, that every scriptural text and teaching is about, every scriptural text has a context, and we actually have to look at intentionality. It's very subjective around religious teaching. So if we're going to look at issues around impact and intentionality that happen a couple of times in this bill in a couple of places, then we really have to look at some objective tests or something. It's going to take a little bit more time because, if you like, the harm that could be felt as a result of this teaching needs to be taken into consideration in terms of motivation and intentionality. So it's a very fraught area.
Yes. And you mentioned having a consultation with the 18 representatives. How long would that ordinarily take you to do?
Well, our Eastern churches had Christmas last week, so this is their Christmas holiday. So, no, the consultation right now, with notice, probably we could organise something for next week. But on the other hand, we don't want to stand in the way of some response being made. But
sure, no, and it's not about that. This is about this. These are complex laws, and I think all of you are very. It's very good of you to participate in this process and commit to providing statements, as others have said, submissions rather. So no, I certainly take that point. Bishop Stead, did you reference the exemption in your opening statement? Forgive me, I recall.
I didn't in my opening statement, but I certainly do have a comment to make.
Yes, please.
I'd like to argue that it's absolutely essential to maintain the religious text exemption, and in fact that the present form of it isn't sufficient. And that comment stands with the bill in its present form, and it's magnified if the bill were to include other protected attributes. But even in its present form, well, let me state the obvious. I think the desire to remove the clause is because there is a concern about some passages in the Quran that are understood to be denigrating of Jews, anti-Semitic, and it sounds noble to have a law that says we're going to ban anti-Semitism in scriptures, but I think we need to be aware that won't just ban the Quran, it will ban, for example, quite a bit of the New Testament. Lillian Freudman, in her book Antisemitism in the New Testament, that kind of tells you from the title, she argues that Jesus' words about the Jews in John 8:44, you are the devil, this is her words, make anti-Semitism respectable and encourage aggression against Jews with, quotes, inspiration like this, close quotes, pious churchgoers have considered it acceptable at a minimum, and perhaps even their Christian duty, to join in massive attacks on Jews, end quote. So there is an argument that John's gospel is anti-Semitic. Like I'm a theologian, I'd love to, I'm not conceding that point. Yeah. I don't believe it is anti-Semitic. But the point is that there is an example of an influential scholar who could invoke Section 82BF on the basis of a reasonable apprehension of fear that people are going to join in massive attacks on Jews. So as soon as you say, look, there are passages in the Quran that are denigrating of Jewish people, the similar charge could be levelled against the scriptures. And in fact, to be just a little bit facetious, I'm an Old Testament scholar, I'd say the same thing about a lot of the Old Testament. It's actually anti-Semitic. The Ezekiel chapter 34 is a scathing critique of the leaders of Israel. So if we're going to say we're going to ban all things which are critical of Jewish people or people on the basis of race, we're going to be banning a whole lot of scriptures. Now, that, as I said, that's even magnified if you to expand out other protected attributes, which is not presently in the bill,
yes.
but has been flagged that there's it seems that there's every likelihood that this will become a stepping stone to expanding this out. The bill will step up. The religious text exemption becomes even more necessary on two different fronts. One, because of the exclusive truth claims of one religion against another. And so in the UK, where they have similar provisions, you end up going to court because Muslims are offended about what Christians say about the Prophet and Muhammad and vice versa. And because by their very nature, religions make truth claims about superiority. I believe that Christianity is superior to Judaism. I don't believe that Christians are superior to Jews, but I believe that Jesus is the way to heaven. Let me put it out there. Now, if that's going to end me subject to a 5-year criminal sanction, we've got there's a real problem with this law. So
yes.
Those kind of law completing truth claims, as well as the statements that religions make about sexuality and gender, where those things cause offence, where those things might lead someone to fear harassment or fear violence. Again, that comes within the ambit of the clause if it's not limited to racial hatred.
Indeed, and you've just encapsulated that concern that's been expressed by a number of others from various Christian faiths about potential implications. Before I hand over the call, just so I understand, Bishop Stead, I think, did you say at the very least we should be excising out section 82BF for further consideration, if anything were else?
Section 80, full stop, 2BF.
Yes, that one.
That's the whole section for serious racial vilification.
Yes, that's your suggestion. Okay, look, thank you very much for that. Chair, back to you.
All right, thanks. Dr. Reid.
Everybody, and thank you for your attendance at this committee hearing today. I'm just going to jump straight in. I do apologise. And this is a question open to the entirety of the panel. Are there any concerns that you'd like to make note of with the aggravated sentences for religious and other leaders?
We're politely waiting for everybody else to go first.
Who wants to start?
It all turns on what we understand to be hate crimes. If what we're talking about as hate crimes remain constrained to what's presently in sections 80, 2A, 2B, 2B, B, 2B, 2B, that's two, you know the ones I'm talking about. The current, if the offence we're talking about is force or violence or advocating force or violence, then those things are already crimes. I struggle to see why they're worse crimes if they're committed by a person who is doing religious teaching. So the religious leader definition there is so wide that it would capture most of the people who are doing anything in the church. And if these things are a crime, you just bump up the sentence, which you've already done. I can't see that it needs further aggravation, a further aggravation factor.
I suppose part of the question that I'm sort of indirectly asking in that is that, do you think that leaders in positions of influence have a greater degree of, say, culpability, which should be reflected in any sentencing?
Yes, leaders do, but the definition of leader there is so wide that it will include somebody who runs a midweek Bible study group. So I don't know, it probably in any context could include half of a congregation if you include people who lead a Bible study, who lead Sunday school. the definition is so wide. So I'm okay with the idea that you apply a higher standard of, to me, as somebody who is theologically trained and in the position of leadership. If it was limited to people who were congregational leaders, I can see the warrant for that. But what we describe as people in leadership in Christian circles encompasses people who are not theologically trained, and therefore we're putting a degree of culpability upon them which isn't commensurate with their understanding.
Thank you. Does anyone else want to add to that question?
I think from our perspective, we would have to definitely agree with what Bishop Michael just said. It's the issue with how it's worded in this current bill is the ambiguity of what a leader is and who is encompassed by that. There's no doubt that people in, as a priest or position of power or a bishop do have and should have a extra moral obligation, but it's how does the Parliament want that to be? How far down does the Parliament want that to go? Or is the Parliament willing to walk that away and just say, you know what, it's up to the courts to decide who is a leader?
Comment. Sorry, can you hear me now?
Yep, gotcha.
Okay. Sorry, it's just, I guess Michael said some, Will said some. I guess all I'm going to say is one of the comments that were taken on board by the Attorney General's team yesterday in our briefing was our concern about, who is a leader. In this case, there was very broad definitions being made. People were working in religious pastoral care or secular pastoral care, giving religious instruction. Is it the youth group leader on a Friday night? Who are we talking about? I think to Will's point, and it comes from later discussion and more discussion, we have to take this again to the church leaders. It is about can we not leave it to the courts to make a decision about the decision on leadership, authority, influence, and making that decision. I think, Will, in your submission, you made your presentation, you made a point about, almost the overreaching nature of some of this draft of the bill, and maybe in this area we'll have to come back. Maybe not even in our submission. What we'll do is flag that we need to come back around these aggravated offences for preachers and leaders. Certainly in the title, we didn't even have a definition of preacher. So we're talking about preachers and leaders, but we're actually in other places talking about religious or other leaders. People can nominate themselves as a preacher and a leader.
Okay, thank you very much. And I just have one more question, if that's okay, Chair. Just in relation to the new listing regime for prohibited hate groups, does anyone here today have any concerns with regards to that?
I've got particular concerns about the definition of what is a hate crime. So the definition is in section 114A, subsection A.3. At a summary level, the first part of the definition, subsection 1, is fine. It's saying a hate crime is the existing offences in section 80. 2C, 2A, 2B and all of that, as well as the prohibited symbols. Slight concern about section 2, which is a hate crime is retrospectively engaged. So you're now able to declare something to be a hate crime even though it wasn't a crime at the time of commission. Now, I realise it's not making these things a crime, but it does run counter to the general principles of criminal law that you don't make retrospective offences. But the thing that really worries me is section 3, subsection 3, which says that a hate crime is also other conduct which again, could potentially retrospectively, either subsection A1 causes serious harm to a person, or subsection AV creates a serious risk to the health or safety of a section of the public. That's a very low threshold for something to be defined as a hate crime that's going to activate the rest of the bill. Now, note that those things, that's not actually making them hate crimes. It's just saying, for the purposes of the listing regime, this is what's defined to be a hate crime. But now we have this slippage in language, which things are not by their natures hate crimes are being defined to be, with the elasticity around what exactly is serious harm, serious risk, is it psychological harm? Again, I'm enlivened to the potential of the bill being expanded to other attributes, and the arguments that are already being made about Christian teaching causing serious harm, serious psychological harm to people. That then makes Christian teaching hate speech on the basis on which the Minister for AFP could prescribe a Christian group because of that. So the definition there needs to be a consistent definition of what we mean by a hate crime, and defining something which is not a hate crime to be a hate crime just so that we can list the group seems to me an entirely inappropriate use of the term.
Does anyone else want to add to that? Or thank you very much. Does anyone else want to add to that?
We'll have to get much more detailed advice before we can even comment on our submission tomorrow, and then take it to our national church leaders.
Okay.
So.
Thank you. Will, anything? No, you're all good?
I was just going to say, I feel like Bishop Michael has taken all my notes and has read them to you with far more detail.
No, thank you all so much for your time here today. Thank you, Chair.
Yeah. Just to expand on that point, there's a bigger problem that we actually have multiple competing definitions of hate. So hate in this bill goes as low as causing serious harm. Hate is defined in the aggravated sentencing factor sections as hostility, malice or ill will. Hate in the traditional offences is advocating or threatening force or violence. And then we have a new definition of hate, which is something that leads to intimidation, fearing harassment or fearing safety. We're not being consistent about what we actually mean by hate speech. It's just a minefield. It's a definitional minefield, and it demonstrates the haste with which this has been brought together.
Thank you very much. Thank you for your time.
Okay. Nothing else from your end, Jono? No. All right. All right, like clockwork, we're bang on 5:30. Thank you very much, everyone, for your attendance today, particularly on short notice. And if you've been asked to provide any information, please do so to the Secretariat as quickly as you can. We'll also send you a transcript of today's evidence. On that note, thank you again to everyone who has appeared before the committee today. Can I again thank Broadcasting, the Secretariat, all the staff here at Parliament House who have turned this around, Broadcasting, and those are helping with Hansard. And again, everyone for being so accommodating over the last couple of days. On that note, the committee will now adjourn, and look forward to seeing colleagues next week. Thank you.